few times a year.
He's not his away this week.
I guess that's the next one.
John was here a few weeks ago.
Good evening, everybody. Welcome to the Melbourne Township Planning Board meeting. In accordance with Section 5 of the Open Public Meetings Act, Chapter 231, Public Law 1975, be advised that a notice of this meeting was made by posting on the bulletin board, town hall, and mailing to the officially designated newspapers a list of the meeting dates annually, indicating that this meeting would take place at Town Hall at 7:30 p.m. on March 5th, 2025.
Corey Miller,
Here.
Allison Canfield. Here. Michael Cohen.
Here.
Frank Sagamonte.
Here.
Jorge Mastro-Pietro.
Here.
Deborah Nevis.
Here.
Michael Zion.
Here.
Jonathan Baxter.
Here.
Sergey Sivstov.
Here.
Steve Vijay.
Here.
Gaston Helper.
Here. On tonight's agenda, we only have one item. It's application 24003. Just before we start, I'd like to remind everybody to please keep courtroom decorum. When people are up here speaking, please don't speak to them. Wait your turn. Please try and keep the conversations in the audience down so everybody up here can hear and our reporter can hear. Mr. Levine.
Good evening. Thank you, Mr. Chairman, members of the board. Michael Levine with Fox Rothschild here on behalf of the applicant, High Center for Living Judaism, Inc. It's just by way of a little bit of housekeeping and taking stock of where we left things off. Andrew Vicio, our traffic engineer, had provided some supplemental testimony in support of his supplemental traffic report. It was a great deal of questioning, and at the end of the evening, as it was getting late, there were two folks that had said that they did not they had some questions for Mr. Vicio and did not have an opportunity to ask those. So to be perfectly honest, the folks were kind of over my right shoulder. I'm not sure if they're here, who they were. I don't think they identified themselves by name, but I do know that there were two folks that said that they had some questions that they didn't have an opportunity to ask. So I think that's probably the first item of business in terms of my witnesses. And then from there, we have our final witness is our land use planner, Paul Rickey, who's available to testify after Andrew. And then at that point, I would probably just, obviously he'll be subject to questioning. And then at that point, I know that there are some objectors that have submitted some materials in advance, maybe looking to put on a case in opposition. And there's also the opportunity for public comment and statement, not just limited to questions at that stage of the proceedings.
And, I'm sorry, are you finished?
I said, was there a question?
No, I'm waiting for you to finish.
All right. So that's what I have in terms of what we have in store in terms of witnesses and where I think we are. I think the only other unfinished item of business that a number of the board members had asked about was the extent to which the applicant was going to provide additional visual renderings and representations of the application. You may recall, initially, as part of our application, we submitted from the architect floor plans, dimension floor plans, elevations, colored elevations of all four sides of the building, some three-dimensional renderings showing, trying to demonstrate that the HVAC units in the middle of the roof would not be visible given their location and the angle of view. And in addition to that, we had provided on two separate occasions, off-site visual depictions as best we could of what we think the site would look like in a post-development condition, trying to take into account existing mature trees, proposed landscaping, the anticipated location of the building as shown on our site plan. We went through those initially, and then we updated those in order to be consistent with the revised site plans that we had submitted. So in addition to that, there were a series of additional inquiries. Like I think one person pointed out that our visual rendering was from Google Maps, so it's approximately 10 to 12 feet above the ground. Do you have something at 6 feet? We've got other folks, either from the board or members of the public, asking, well, what about the second floor of adjacent homes? That might be an interesting view. We've had requests for 360-degree views, which would obviously involve getting access to private property on at least two of our sides. The short answer is no. The applicant doesn't plan to submit any more of those types of visual depictions or representations. And the main reason is this. I was dismayed to learn, preparing for tonight's meeting, that 2 weeks from now will mark our half-year anniversary, if you will, of the commencement of these proceedings. So we've been at it for nearly a half a year. During that time, the applicant has tried to show a willingness to cooperate, to listen, to take input, to take recommendations, and not just give it lip service, not just kind of nod their heads, but actually look at it, chew on it, and try to incorporate those requests and recommendations into revised plans. Changes large and small. Substantial revisions to the locations of the driveways, one on Old Short Hills Road, trying to line it up with Park Road, one off of Parsonage Hill, pulling it significantly further back from the intersection in order to make it more safe and efficient and reduce queuing. Entirely revising the stormwater management plan to eliminate surface level basins in favor of underground improvements and more green infrastructure that allowed us to maintain more trees, to include more landscaping, to provide a more aesthetic layout. We've agreed to work with your forester to further supplement our landscaping plan and take their recommendations with regard to species and planting and density and what have you. And we've also agreed to a number of conditions of approval if this board were to see fit to approve this application. Everything from agreeing to, post-installation noise testing of the HVAC just to make doubly certain that it's fully compliant with all applicable laws. Voluntarily limited our hours of garbage pickup to not before 7 a.m. We agreed to maintain a 6-foot solid screening fence along the western portion of the property and maintain it so that it remains an effective visual buffer to that neighbor. So these are requests for the additional visuals. They're expensive, they're burdensome. They involve, in many cases, access to private property. So it's a tremendous burden for this nonprofit applicant, but more to the point and more legally relevant, it's a request for information that's not relevant for purposes of the board rendering its decision. The board's job, and you'll hear about this from the planner, you hear about this from me again as part of my closing remarks. We're kind of pushing things up a little bit in order to try to address this issue. But the fact of the matter is our burden and the board's job is limited to looking at what's in the ordinance and demonstrating that we comply. Now, there's a commonly used tool under the municipal land use law of establishing special design districts, whether they're related to historic structures or other, downtown areas, other areas of town that warrant special protection, where they actually adopt design standards, where there's certain limited colors that you can use. There's certain required fenestration and finishings and what have you. So those tools are available. Those tools haven't been used in this instance. There are no objective standards that we can point to give us any sort of guidance as to what would be required. They don't exist. And with that being in the case, the cases are very clear. Pizzo Manton et al., you'll hear about those again from our planner later this evening, hopefully. These kind of nebulous concerns about aesthetic impacts are not legally relevant considerations for purposes of a board weighing an application. The notion of trying, I'm curious about this, or I'd like to see what this looks like, or the neighbors seem to be concerned, maybe we should get some more of this information. That's not within this board's purview. And to ask for substantial amounts of additional irrelevant information half a year into these proceedings, I would maintain is not reasonable.
Mr. Chair, if I may, ask a question of applicant's counsel based on the contention made by applicant's counsel. Ms. Levine, are you saying that those items are not relevant in any land use board application, or are you saying only in an application where that is effectively a fully conforming site plan application and perhaps also a fully conforming conditional use application before a planning board, which I understand is what you contend this application is. And as far as I understand, and Mr. Petto can correct me if I'm wrong, it, at least at this stage, appears to be just that at this time. But is that what you're limiting your remarks to?
Exactly. That's an important consideration, Mr. Warner. And yes, that's an important legally and factually distinction to make.
I appreciate the clarification.
Because we certainly do, and it's yet to be alleged otherwise by any of the board's professional consultants, that we fully conform with all of the conditional use standards and all of the site plan requirements under the ordinance. The MLUL is very clear that with regard to site plan approval, which was one of our two main approvals that we're seeking, if the applicant complies with the site plan standards, the board shall grant approval. It's mandatory language. It's not may or is permissibly or can. It's shall grant site plan approval. Same is true with conditional use standards. If those conditional use standards are met, and the planner will talk about some of the relevant case law with regard to this, that is tantamount to a permitted use, which is a very different thing, as Mr. Warner alludes to something that requires variance relief. In that instance, that burden is on the applicant to affirmatively demonstrate that what they're proposing will not be a substantial detriment to the public good and won't be a substantial impairment of the zone plan and zoning ordinance. those requirements, that burden does not apply if you're a fully conforming application. By conforming to the ordinance requirements are an expression of the governing body's determination of what is protective of the public good. We've heard a lot of comments and complaints from members of the public wondering why this industrial building is being put in this residential area. My first contention is it's not an industrial building in any way, shape, or form, but more to the point, your ordinance allows houses of worship in several residential zones. Under your ordinance, it's where it belongs. Under your ordinance, it's per se appropriate. There is no affirmative obligation on the applicant to come up with views and mock-ups and depictions to prove that outside of complying with the ordinance requirements. And that's what's being asked of this applicant. The same is true with kind of nebulous, subjective, undelineated historical considerations. Again, as I've pointed out before, there are many tools available to provide protections and requirements and standards with regard to historic properties. This town has a very active historic preservation commission. They're very familiar with what those tools are. And you've used some of those tools in town, designating specific sites as historic landmarks, designating certain areas as historic districts. This property is not a landmark and is not a district. It's referenced in your historic preservation element of your master plan as potentially historic, but that has no regulatory effect. The applicant doesn't have to show that it's somehow designing its facility in a way that's compatible with a historic area or a historic place. That's the kind of due process protection that all applicants enjoy and deserve. They need to be able to understand going in what the rules are, what the requirements are, to be able to determine whether they apply or not. In general, good planning considerations, the cases are clear, do not satisfy that standard. So here we are again, half a year in. We're about later on this evening to hear requests for the board to consider and talk about and ruminate over zoning board of adjustment applications with regard to different properties at different points in time, planning board applications from years ago on different properties, a settlement agreement that doesn't involve this property, which is only relevant for purposes of trying to paint the applicant as bad people, just as simply an ad hominem argument that's not relevant to this property, this application before this board. It's exactly why the MLUO has the time limits for taking action, is to avoid requirements and endless recitations of superfluous information that this applicant's been trying to resist from day one. So we've granted many extensions, but there comes a time when enough is enough, and the applicant is pretty much there. As the board is really very well aware, there's a very long and very unfortunate history of litigation involving the town and this particular applicant. They've come and tried to pursue these proceedings, trying to be reasonable, trying to approach it with an open mind and open ears, and I think they've demonstrated those efforts in a number of ways. At the end of the day, these folks just want to worship. They want to worship the way that they have been literally for thousands of years. And they've repeatedly shown a willingness and a dedication to fight to protect that right. I have absolutely no reason to believe that that's going to stop anytime soon. So with us being a half a year in, we're looking forward to trying to wrap up our application and proceed in an efficient way with facts and issues that are within the relatively narrow scope of this board's jurisdiction in order to try to reach a decision. So that is an extraordinarily long-winded way of saying we don't intend to submit any more visual depictions.
Okay. If I may, to that effect, I still want the request to stand. There were certain claims that were made about shielding and screening, and I still would like to know a little bit more about the noise reduction that's coming from the landscaping that's going to be in between the residents and the house of worship. So even though it may not be in our purview to deny an application, I do think that you do have enough grounds to request that we have these different views. And actually, I still think the landscape architect would be very beneficial. There are several people up here that have questions about it, and we're trying to make this transition for our community as gracefully as possible. It is a huge change for the neighborhood. It is one of the, I don't know when the last house of worship was built in this town, so this is a new thing for the town as well. We're trying to keep the residents in mind. We're trying to keep you in mind. But in order to do our due diligence, we need certain information. So I would still ask that we do receive the different, could you tell me what the name of the 360 multi-season reviews, what is it called?
There's no formality to it. I might have used the phrase 360-degree four-season, but that doesn't, there's no, you've heard argument from applicants' counsel, we may hear a different argument from different counsel, but there's no mandatory requirement that anyone provide a 360-degree four-season view of anything under the law, even if there are variances, there is variance relief. But if that's something the board wishes to see, then certainly a request be made from the applicant. Applicant can make the determination whether to adhere to the request or not. And you've heard at least argument as to why the applicant contends they should not have to do that. But one could always change one's mind, or not.
Thank you.
Thank you, Mr. Chairman. So I think that brings us to Andrew.
Right, and if I may, Mr. Chairman, we do at least have a list of those who did ask questions. I do recall a couple of individuals, two literally, who asked to question Mr. Vicio when we ran out of time, so to speak, the last evening that we were here. Before we go there, and notwithstanding Mr. Levine's opening, I'd be remiss if I didn't ask, nevertheless, right now, and I'll ask again at the end of the evening if I have to, that as we stand, where I sit, the board currently has an extension of time to act from the applicant until tomorrow, if I recall correctly. Double check me, Eileen, March 19 next meeting?
It was not here, so I.
2 weeks, 14, today's the 5th, I'm gonna do the math, 19th, I know. And so that would be a request on behalf of the board for an extension of time to act until at least March 20th.
Yes, granted.
Thank you, Counselor, and thank you, applicant. I'm sorry, bear with me 1 second. Okay. And then, so we do have two individuals, as I recall, and we do have the list of those who have already questioned to ask Mr. Vicio questions. Based on his testimony at the last hearing only. Thank you, Mr. Chairman. Sorry. And again, as everyone's heard ad nauseum, so why not say it again? Each time a witness testifies, the questioning is only on the new testimony, not old testimony, and not something that they did not testify regarding.
Okay, I'm Ted Kuntz in Short Hills. I just have a question for you, Andrew. The traffic study, did you include any sensitivity analysis in your analysis? If the day school, and I wanted to focus on the day school because that's really going to be a big part of the activity here. What if that day school reached its capacity, which could be 3 or 4 times the number of students that I think you probably ran your test on. So I just want to know, what number of students did you include when you ran your test? And if you did do any sensitivity analysis, if the number of students could be a lot greater, and consequently the corresponding traffic would be higher.
So 2 questions, right? Mr. Vicio, you might need a microphone. We might be going through the battery
You're going to use this one.
issue again, but I don't know. That seems to be a mulberry bush that we circulate every meeting. So there you go. safer
I
bet.
don't think that,
This one was-
There we go.
It works.
We looked at the daycare operations in two fashions. One based on the size or the floor area dedicated to that particular use. And also what we anticipate the licensed capacity would be. So we did not say average attendance. We did not say, well, there may be 10% absentee rates. We ran the numbers based on the licensed capacity, compared that to the size of the daycare component of this use. And we ran all of our analyses based on the higher of those two ways of running our calculations.
And what were those numbers? What were the number of students that you then assumed?
72,
You said assume 72 students
Correct.
in your analysis. Okay.
correct.
And did you account for the classrooms upstairs that could be converted into, daycare use as well? No, you did not.
That's not my understanding of what those classrooms are intended to be used as.
Well, they're not intended, but they could be. If there was a demand, if the demand is there, they have the capacity to increase that number. So from
My understanding is that the applicant has presented architectural plans indicating that 5,261 square feet of floor area will be allocated to the daycare center. Should the applicant desire to expand the daycare center, I would have to defer to counsel on what their obligations would be with respect to approvals that may or may not be needed before this board. But that is what the application documents have presented thus far.
Okay. If you did see a traffic increase, a corresponding traffic increase to added capacity, say double or triple that, would the congestion resulting from that result in greater time delays, not just in a linear fashion, but more in an exponential fashion in your time delay calculations?
I don't have any reason to think that the numbers that we're utilizing are underrepresenting what the traffic generation of that particular component of the use would generate.
It was a hypothetical. If you did end up with doubling the number of capacity of students, would that result in not just a linear increase in the traffic delays, but in more of an exponential one? Just a question of how you do your work.
If the size of the daycare center increased, there would be an associated degradation of or worsening of delay associated with those trips. But again, that hypothetical scenario is not before the board.
Okay, well, the board may want to consider, because this,
Sir, that might be on the argumentative side.
Oh, okay, I'm sorry, I was just thinking it would,
Right, but now the next question.
I was just wanted to bring up that point, that, considering that this is a
The
long-range project.
points would be by testimony in the public
Got it,
comment
got
period
it, okay.
forthcoming.
Great, thank you. Thanks a lot.
And if I could just to kind of address your point, sir.
Was there not a stipulation with respect to capacity, if I recall?
Yeah, that's exactly what I was going to remind the board of. That Joe had actually recommended that in order to kind of keep a finger on the pulse of this situation, because any approval would be relying on the traffic report and the numbers and the projections that we had submitted. Initially, we were thinking in terms of student population, and his recommendation was it would be easier to monitor, and easier to check, and easier to enforce if it were tied to the square footage that was devoted to the use.
But by the way, you say Joe, you're referring to Mr. Fisher.
Yes, I'm sorry.
The board's
Right,
independent traffic consultant, correct?
Yes.
Thank you.
Spend a lot of time together, we just get too familiar.
Well, that's for the record.
Yes, for the record. Brightview Engineering, that's correct. And so we went and had our architect calculate that number down to the square foot indicated on the plans, and actually had submitted suggested condition of approval language that would acknowledge that we'd be limited to that amount of square footage devoted to this use, and if that were to increase, that we would have to get updated traffic information and have it submitted for review and approval by the board's engineer and I think the zoning officer as well, if I recall. But anyway, in anticipation of that issue, so that it couldn't just have rampant change and wonder what there would result in an adverse traffic impact.
Mr. Warner,
Did you get to finish your question previously or?
I didn't come tonight. I just had one quick question that I didn't get to.
I'm sorry, you didn't come late? I'm sorry, you
I
didn't come
didn't
last
get to
time?
ask this question last
Oh.
time. May I ask it, yes or no? That's
It's up
up,
to-
whatever
it's up to
you
the
decide.
chair.
Mr.
Yes.
Okay.
She definitely was here and asked a series of questions. I don't know why.
I think she's conceded that. She's asking if she could ask
Just
one
two quick
more,
questions, two
two more
questions. Yep,
questions.
it's really
It's up to
fast.
the discretion of the chair.
Bill-
Why don't you let the chair
Based
rule?
upon his testimony,
Yes.
that's it?
Yeah.
Okay.
So, first question is, you did videos to
And I'm sorry,
monitor.
name and address again.
Oh, Christine Best, 15 Fairfield Terrace, Short Hills. Did you obviously monitored the traffic to make all these, fact-based statements. Do you have a video monitoring that you provided to the traffic engineer? Did they actually see your raw data from a video perspective?
That's a question for them.
No, I'm asking, did you give them the raw data?
I provided them the data, but I can't answer whether or not they viewed it.
No, I wasn't asking that. I said, so you did
Ma'am,
the
I think we
video.
got it.
You gave them the
She asked you if you
video
gave them the monitor and you said yes?
Yes.
Okay.
It wasn't
good.
your calculated data, it was the
Next
actual
question.
footage. Okay, that's all I wanted to, so the other question is, you said that you didn't do a visual modeling of the, actual parking lot space. And I wanted to understand just quickly, how you calculated how the flow is going to go on internally on the property, and then exit out. Like, did you just use theoretical math equations or did you do an animated flow? I just wanted to understand how you came up with those calculations of the flow out of the property, like after service, for example.
We used the ambient traffic patterns that exist today
Mhm.
and distributed the trips in and out of the site
Mhm.
based on those volumes.
Thank you so much.
I don't know if the second person who was here last time is here again, who wanted to ask a question. Apparently not.
We have one more question, or?
Can I come on?
Sure.
And just for clarification, you did not ask a question of this witness at the last hearing, correct?
No, sorry, I haven't been here for a while.
Okay. And Mr. Levine, no objection to this member of the public asking a question of Mr. Vishio based on his testimony at the last hearing?
I'm not fully aware of the testimony from the last hearing, but I did have a question for the traffic.
With the chair's permission, you will find out. I think the chair's permitting it.
Yes, yeah,
Okay.
Mr. Lynn, you're okay? Thank you.
Okay, thank you.
Please.
Without objection.
Sure. My name is Alana Mizrahi. I live at Park Circle. My question for you is, as a resident exiting onto our Old Short Hills Road and oftentimes making a left-handed turn, exiting from Park Road has been a very challenging exercise. And the current plans envision a four-way intersection now with the egress of the parking lot. It's challenging enough to manage the traffic flying down Old Short Hills Road, as well as up on Short Hills Road, crossing at Parsonage, and now adding another intersection. By the way, I've been
Do you
hit.
have
My
Do you have a question for me?
yeah. My question is, why was the decision made to move the exit onto Old Short Hills Road at that specific location? I know it was initially further up. I'd also be curious as to why it hasn't been considered to do it onto Parsonage, where you don't have the same speed of traffic. Anyway, those are my questions.
So I testified to this at the last hearing, but The intersection of Old Short Hills Road and Park Road, we are calculating using default values there to be acceptable levels of service and delay. On top of that, I personally watched hours of video of this intersection and timed the amount of delay for vehicles exiting Park Road onto Old Short Hills Road. I found that the average delay was 19 seconds for vehicles exiting Park Road onto Old Short Hills Road. Our calculated values using, default inputs is 28 seconds. So our analysis, which has been reviewed by the board's traffic engineer, shows generally acceptable levels of service per industry standards. And on top of that, real-world data and meticulous observations shows that the actual values are even less than what we're showing in our report.
Have you measured the time it takes to make a left-hand turn at any other intersections along Old Short Hills Road?
No. Other than Parsonage Hill Road
And how much
and Park Road, no.
and how much time do you give a vehicle to make a turn, a left-hand turn out of that intersection? Personally, I have to speed and gun to get out of that intersection most times.
Ma'am, I'm sorry, we have to be careful not to testify. There's some testimony inherent in questioning, but then there's some that really doesn't have to be there.
Sure.
I'm sorry, could you repeat the question?
The question is, how much time do you provide a vehicle to make a left-hand turn? Like, what's your average window of cars,
Yep.
Not passing on either side?
It depends on the geometry of the intersection. For a T intersection, it's on the order of 6.5 seconds of a gap necessary in traffic to perform a left turn. For a four-leg intersection, that goes up slightly. I want to say the number is approximately 7.1, but I could be off by a tenth of a second here or there.
Did any of your calculations include, oftentimes what happens at that intersection is there's a backup of vehicles waiting to left turn onto Parsonage. And so that's oftentimes the allowance of cars to get out of Park Road. Can you quantify how often that was a factor in the maneuver?
Yeah, I noticed an extensive queue one time during the my manual delay calculations, and that was taken into effect in the numbers that I just testified to.
And can you remind me, just because I don't recall, what was the specific date of measure?
Sure. I'm gonna have to go back, it was a few reports ago.
While you're looking for that, just because I think it related to one of the questions, can you correct my recollection if it's not correct? But that intersection was moved to be directly across because that was deemed safer, correct?
Correct, that was, thank you, I missed that question, but yes, that was a request of the board's traffic engineer to create a safer condition, as the initial orientation had the driveway and Park Road offset from each other, which some motorists could find complicated due to the offset nature of that intersection. So where we have the driveway now was a direct request of the board's professional. The traffic volumes. Wednesday, November 20th, 2024 from 7 a.m. to 7 p.m. And I would like to take this moment to again state that that was not the week of Thanksgiving, as has been misconstrued in the past.
I had asked before, but was there a reason why an exit or the primary exit wasn't considered on Parsonage as opposed to Old Short Hills Road where the traffic seems to run much faster in both directions?
There are exits on both roadways.
And is there a primary exit versus a sort of secondary exit in terms of the direction of traffic?
No, one driveway has not been identified as primary or secondary.
Thank you very much.
Thank you. Any other questions from the public? Number only pertaining to his testimony from last meeting.
Sure. So I was not in the last meeting, but you can tell me if it does not pertain and then I walk back. So I'm Ritesh Singh, resident of Short Hills.
Your name, spell it.
Ritesh Singh, Riteesh, last name Singh, Singh,
And your address.
33 Jefferson Avenue. So my question is, how did you decide it will only be 40 people for this study? 40, and that's my understanding that is 40 here versus capacity of 300 for the building. Traffic studies for 40.
I'm not sure where we cited 40 people anywhere in our report.
So what is the size of, what traffic study is done for how much incremental cost of vehicles?
So we projected the amount of traffic that would be generated by this development using both components of what's being proposed. House of worship, synagogue, and a daycare center. We used industry standard methods to project the amount of traffic, and we combined those two and added it to the roadway network, and that was how we conducted our analyses. The number of trips entering and exiting the site is different for every peak hour that we studied. We studied 5 different peak hours.
What is the maximum peak hour that you have an exit at that time?
96 total trips,
Within how much time is that out?
1 hour.
So my question is more, if the capacity is 300, why only 96 trips in that 1 hour?
Oh, if the capacity of the synagogue is more people? So that's, our analysis is a typical weekday morning peak hour. The rabbi testified that he would like to establish morning prayer on weekdays. I believe he testified on the order of 10 to 15 people he is hopeful would attend that. That falls generally within the values that the Institute of Transportation Engineers projects for a synagogue of that size. In fact, the Institute of Transportation Engineers are much higher when you consider they combined volumes entering and exiting the site in a single peak hour, which is probably unlikely. It's probably people will arrive, pray, and then depart. But we did not use the estimate of the rabbi to perform our traffic analysis. We used industry standard rates based on the Institute of Transportation Engineers trip generation manual for a synagogue of this size.
And that size is 300, or is that size, what is the number that is used in those calculations?
Floor area,
Floor area, 21,000 square feet, that's the floor area.
that's the combined floor area of the building.
Yeah.
15,776 square feet are dedicated to the house of worship, or the synagogue,
So 15,000 was what was used to determine this number.
precisely.
Thanks, that was my question.
Sure. Thank you.
Thank you.
Any other questions from the public? Any other questions from the board?
I have a question. Is there any threshold for a level of traffic that requires the installation of a traffic light? I mean, would it be helpful if there was like a traffic light? I know I have a tough time making a left from Parsonage Hill to Old Short Hills Road. Is there any, I mean, do you guys come up with a threshold where you say this intersection needs a traffic light?
It's extremely descriptive by the Federal Highway Administration publishes something called the Manual on Uniform Traffic Control Devices. And there is a chapter within that guidebook that is extremely prescriptive about the conditions that need to be in place in order for a traffic signal to be warranted. There are 8 or 9 traffic signal warrants that are applicable to any particular situation. And we have not performed, the analysis that is performed to take a look at all of those warrants is typically called the traffic signal warrant analysis. We have not performed traffic signal warrant analysis. However, I have performed very preliminary capacity analysis models to see what the impact of a traffic signal would be at this location. I testified to this at the last hearing, but the results that I found where a traffic signal were to be constructed and installed at this intersection alone without any improvements would significantly deteriorate levels of service and increase delay for Old Short Hills Road. Currently, northbound and southbound traffic on Old Short Hills Road is essentially a free flow condition, right? They don't have to yield to anyone other than northbound left turns from Old Short Hills Road to Parsonage Hill Road. So inherent to the construction of a traffic signal, traffic on the main line would be stopped for a certain amount of time, and those queues would build, and there would be delays associated with that. So a traffic signal alone, in my opinion, based on the preliminary analyses that I've conducted, would not be a panacea for the experience that residents experience on a day-to-day basis here.
Do you think if they installed a traffic signal, it would be easier for people in Park to get out of their street?
On Park?
Yeah.
No, significantly harder unless there was striping that indicates that drivers are to not block the box in front of Park Road. Because what would happen with a traffic signal is, as soon as that traffic signal indication, if you're traveling northbound on Old Short Hills Road, and that traffic signal indication turns red, you're going to very quickly see a queue build up towards the south. That queue will very frequently, if not every single cycle during the peak hours, block Park Road. The way to mitigate that would be to stripe do not block the box markings so people would be able to get in and out of Park Road. I hope that answers your question.
With your analysis on the traffic signal, are you taking into account just the standard traffic signal that's time-based, or it's my understanding that there's smarter traffic signals out there that can sense whether there's cars, perhaps at one of the intersections, and so, under normal circumstances, if no one's exiting the property and no one's trying to come to the park, traffic can flow freely, but when a car pulls up, then it can kick off the algorithm, that cause it to change. So was your analysis just based on a standard signal where you made your determination that it would actually make conditions worse? Or did you also look into, well, if we used one of these smart signals, what would that do?
Yeah, the analysis was for an actuated traffic signal. And when I say actuation, I mean sensors, like you said, that detect the presence of vehicles on a minor approach that allow the traffic signal controller to decide whether or not to give that minor approach time. What would happen during the peak hours is that there would essentially every single cycle be a vehicle waiting on Parsonage Hill Road that would actuate the signal, and the signal would give Parsonage Hill Road time, which would thus stop Old Short Hills Road traffic. During significantly off-peak times or overnight periods, you might see situations where the traffic is only on Old Short Hills Road and there's no traffic on the side street. In those cases, the main line, Old Short Hills Road, might see a very long, consistent green without giving any green time to Parsonage Hill Road. But that would be off-peak. During the peaks, even with a smart traffic signal, as you said, that side street is going to be actuated every single cycle.
To be clear, the side street you're talking about, I'm talking about Park and then the exit from the proposed development, right? And it sounds like you're talking about the signal being actuated as Parsonage Hill Road.
I think I perhaps misunderstood where the traffic signal you're suggesting would be located.
So now you're creating a new four-way intersection. There wasn't one before, right? If you had the traffic signal at that new four-way intersection, what would the impact be there? Would that improve service for residents on Park Road, and people exiting or entering the proposed development?
So at the intersection of Old Short Hills Road with Park Road and the new site driveway.
Right.
Going back to the discussion we just had about traffic signal warrants, that intersection would be far below any threshold that would warrant a traffic signal. And again, I think that even if the side streets, whether it be Park Road or the side driveway, were actuated relatively infrequently, it would still stop traffic on the main line, and main line being Old Short Hills Road, and result in extensive delay and queuing. I did not perform the.
So we have a facility here that's going to service.
I'm sorry,
you gotta-
can the board members move the mics
Yeah.
closer? Very hard to hear, and it's probably harder for the public.
Yeah, I just want to know, since we're building a facility that's going to be servicing children, right?
Mhm.
Isn't it better to have the traffic slower? I mean, you're saying, well, we're going to install a traffic signal, that's going to slow down the traffic. But we have kids, right, in these cars. Don't we want to slow down the traffic?
There are many ways to calm traffic. Installing a traffic signal for the sole intent of creating extensive delays is not a traditional way to calm traffic. Traditional ways to calm traffic are lowering speed limits and doing so with traffic calming measures like lane narrowing, speed feedback signs, on local roads, speed humps, measures as extensive as roundabouts. There's a whole concentration within the traffic engineering field that focuses on roadway safety and traffic calming. And installing a traffic signal just to essentially artificially create delay is something that I think would cause more harm than good, because it might lead to driver frustration and erratic behavior.
You don't think would it be safer for a person with kids in the car to have a traffic signal to make the left from Parsonage Hill Road onto Old Short Hills Road? Would that be safer, or do you think it'd be less safe?
Are we talking about a traffic signal now at Old Short Hills Road and Parsonage Hill Road? I think that you would have to weigh how significant the delay is and the queuing is on Old Short Hills Road with what the benefit would be to the side street. I'm not, when I say increased delay as a result of the traffic signal, I'm talking about significant amounts of delay that would likely result in significant pushback from not just the immediate vicinity, but the 20,000 vehicles that travel along Old Short Hills Road on a daily
The probability
basis.
of an accident would be increased or decreased if there was a traffic light installed?
It depends on the type of crash that you're talking about. If installing a traffic signal does not in and of itself eliminate all traffic crashes. It tends to increase rear end crashes. It also tends to decrease right angle crashes and left turn crashes. Based on the data that we have, right angle crashes and left turn crashes are relatively infrequent at this location. We've conducted an extensive safety analysis at this intersection. So we started that effort by submitting an open request to the township for crash records at this intersection from 2015 to 2024. The township responded with only 20 reports for representing 19 crashes, which I, as a professional, thought to be on the low end. So what I did independently was go to another resource called Safety Voyager, which NJDOT publishes, and I cross-checked using that resource and the data that was provided to us by the township. I found more crashes. So when I provide these numbers, I would like for the board and its professionals to know that I vetted these numbers extremely thoroughly, and the numbers that the amount of left turn, right angle crashes is still extremely low. Only 10 crashes involved a turning vehicle over the course of 9 years. So about 1.1 per year at this intersection. Of the 42 crashes that we found, only 5 resulted in an injury, which equates to 12%, which is significantly lower than the injury rate for crashes at unsignalized intersections along county roadways throughout the state. The statewide average for an intersection of this type is 28% of crashes resulting in injuries. So the number of left turn and right angle crashes that you would be hoping to prevent with the installation of a traffic signal is already low.
Has pro forma for the additional traffic from the facility?
I did not
That's
perform,
existing. It's not performing.
that's not projecting what the crash rate would be in the future with the development, correct?
Any other questions? Nope. Mr. Lean, can you please call your next witness?
Yeah, absolutely. Andrew, thank you.
Sorry.
Yes,
Can I
thank
just, should we ask our professional if he concurs with everything that?
Certainly. Mr. Fishinger, please.
Thank you.
Good evening, Joe Fishinger with Brightview Engineering. Generally speaking, everything Mr. Vecchio said is correct. I I didn't verify all the crash numbers that he quoted verbatim, but they're consistent with my analysis. His references to the MUTCD and those requirements is correct. Everything he said is consistent with engineering standards. The one thing I would add, just as a benchmark, and there are other factors than just crashes, but for example, one of those 9 traffic signal warrants is with certain volume thresholds, they want you to see you have 5 crashes in 12 months that are correctable by a signal, and those are the right angle and left turn crashes. And Mr. Vicio is correct that generally speaking, installing a traffic signal trades right angle and left turn crashes for rear end crashes. And when we do that, it's the lesser of two evils, because as you can imagine, if you get hit in a right angle crash, you're hit on the car door, there's a lot less car to protect you. If it's a rear end crash, it's less likely to result in an injury because the cars are better designed to absorb that impact front to back than they are if someone's hitting you from the side. So whether Mr. Vicio added a crash or subtracted a crash, the numbers that he's quoting aren't even close to the crash thresholds that the federal government requires to warrant a signal.
Thank you.
Paul?
Would you just raise your right? Do you swear from testimony you're about to give in this proceeding be the truth, whole truth, nothing but the truth?
I do.
Your name for the record, spelling your name, please.
It's Paul Ricky, R-I-C-C-I.
Thank you.
Oh, could you just acquaint the board with your educational background and professional experience, please?
Sure. I'm a licensed professional planner in the state of New Jersey. I've been licensed since the year 2000. I'm also a member of the American Institute of Certified Planners, or our national certification. I have a master's degree in city and regional planning, which I received in 1997 from Rutgers University. I'm currently a municipal planning consultant for 6 towns. I also testify regularly in front of boards. I've been qualified in over 250 boards throughout the state, including Milburn.
We can request that Mr. Ricky be recognized and testify as an expert in land use planning, if I may?
Yes, your license is current?
It is.
Yes, please, as a planner.
Thank you, Mr. Chairman. So Paul, I take it you're familiar with the application that's before the board?
I am, yes.
And have you had an opportunity to review the ordinance here in Milburn and the underlying master plan?
I have, yes.
Have you formed an opinion as to whether or not this application is a good candidate for conditional use and site plan approval?
Sure. And typically I speak pretty freely, but considering the context of this application, my testimony is pretty limited, but I did give it a considerable amount of thought. So I want to make sure my thoughts are clear on the record as part of this application. So I may rely on my outline a little bit more than I traditionally do. So I was really called they asked me to look at this application and to really form a planning opinion as to its appropriateness. Typically, when I receive a call like that, there are variances involved. And traditionally, I would speak to those proofs to justify variance relief. That does not exist as part of this application. I reviewed the professional reports from your planner. I have not seen anything from your zoning officer, from your engineer that indicates that there are any variances required. So my testimony moves forward based on the fact that no variances are required. Again, I know this has been a long process, but again, a little bit of background. We're in your residential 3 district, which permits single-family homes and conditionally permits houses of worship and schools subject to the same standards. Radio antennas are also conditionally permitted. Generally, I'm going to come to this conclusion several times, but I reviewed your zoning code, your master plan, and again, your professional reports, and it's clear that this application results in sound land use planning. We have an application that meets all the conditional use requirements for houses of worship. And you'll hear this from your attorney and your planner, but when a conditional use meets all its requirements, it's the same as a permitted use and is treated the same way under law. And these conditional use standards include proper street frontage, minimum lot area of 3 acres, minimum lot frontage, maximum lot depth, proper location of access, lot coverage, yard setbacks, buffer to residential use or zone, parking setbacks, and building height. Again, here we have no variances, so there's no need to commonly address the positive criteria. Traditionally, I have to address how this advances a purpose of the municipal land use law, and then how these variances can be granted, largely depending on the type of variance, without a substantial detriment to the public good, without a substantial impairment to your zone plan. None of those requirements exist as part of this application. Because we meet your code, there are no substantial negative impacts to the neighboring property owners or the public good as a matter of law. And I also found, as part of this application, this has been an application that has been responsive to the board's public concerns regarding many aspects, which include but are not limited to stormwater management aspects. I believe I've heard the testimony that a less engineered, more aesthetically pleasing design with natural rather than man-made features was specifically designed with the vegetative filter strip. The landscaping, there was a removal of the basin that resulted in less tree removal. The landscaping plan is also expansive in my review. 83 deciduous trees, 86 evergreen trees, 150 shrubs on a 3-acre property. That's substantial planting in my opinion. The relocation of the trash enclosure, relocation of the playground, including the addition of bollards to protect that playground. The applicant addressed all comments of the professional reports. We already heard from Mr. Levine tonight how the driveways previously were relocated, agreed to a screening fence. I think we agreed to a noise test after the fact, garbage pickup after 7 a.m. And I may be missing something, but that largely summarizes what I heard. It's also important to recognize while the use is permitted, under law, it's also an inherently beneficial use. And that's a use that promotes the general welfare of the community as a matter of right. So even when religious uses are not permitted within municipal zoning regulations, their negative impacts are viewed under a more relaxed standard. While these more relaxed standards do not apply here, it speaks to the significance of the proposed house of worship within the courts and under our Constitution. So to leave my outline for a second, if this use wasn't permitted in the zone and it's an inherently beneficial use, as a matter of law, it's considered to be appropriate in any zoning district within your community. And it would automatically meet the positive criteria under the law because it's an inherently beneficial use. Regarding traffic, a planning board has no authority to deny a site plan because of its anticipated detrimental impact on off-track traffic conditions. Planning for traffic is an exercise of the zoning power vested in the governing body. The planning board may go no further than to condition approval on 1, improvements to on-track entrances and exits, and contributions to off-track improvements made necessary by the on-track development. And that's from the North Brunswick case. There's also the RLUPA. Freedom of religion, as this board has probably heard a number of times, is protected under the U.S. Constitution. The federal government enacted the Religious Land Use and Institutionalized Persons Act, or RLUPA, of 2000 after hearing testimony that land use and zoning regulations often burden religious institutions seeking to exercise their faith, I have salty dinner tonight, as protected by the U.S. Constitution. One of the express purposes is to protect religious institutions from the imposition and implementation of land use regulations that are unreasonably burdensome on the exercise of religion.
In summary, the act sought to limit rights of governmental entities to impose a substantial burden on religious institutions and prohibit government entities from totally excluding or unreasonably limiting religious institutions on less than equal terms with non-religious institutions. So when you see your code, standards are the same in your code for schools and religious institutions in this zone. Also under our LUPA, a conforming application cannot be denied without sufficient justification. I also reviewed your master plan, specifically your 2018 master plan. The examination report speaks to your ordinance regarding houses of worship. Ordinance number 2417-13, and it's regarding conditional uses of house of worship, schools and residential zones. The ordinance was intended to amend the provisions of the land development ordinance to modify the conditions set forth for conditional uses of schools and houses of worship. And just to point out, when I see that -13, that tells me that occurred in 2013, that ordinance change. So just to repeat, the ordinance was intended to amend the provisions of the land development ordinance to modify the conditions set forth for conditional uses of schools and houses of worship in residential zones so they are consistent with both sound planning principles and applicable case law, and also to adjust the parking requirements for places of assembly, schools, and houses of worship accordingly. In this regard, the basis for the existing zoning ordinance was to ensure that sound land use planning occurs associated with religious land uses. So it's clear that this application advances the township's master plan as well. Finally, as a planner, I'm aware of the Pizzo-Manton case, which was mentioned by our attorney. The key findings of that case are the planning board's authority in reviewing an application for site plan approval is limited to determining whether the development plan conforms with the zoning ordinance and the applicable provisions of the site plan ordinance. If the application meets all the requirements of the zoning ordinance and there are no issues pertaining to safety, the board must approve an application even if it doesn't feel right. And this is necessary to ensure that the land use process is predictable. So in summary, my planning conclusions are as follows. Because this is a conforming application, there are no substantial negative impacts. On the positive side of the application, the general welfare associated with religious uses results in significant public interest. And the applicant has also satisfactorily demonstrated that the property can accommodate the proposed development in the context which it is placed. So very limited testimony.
Are there any questions?
I do have a question. Can you just define insignificant impact?
What do you mean insignificant?
You stated that.
Well,
There's no significant impact, but
yes.
yes.
As a matter of law, when you testify for a variance application, I need to testify that there be no substantial detriment to substantial is what the term of art is, substantial detriment or substantial impact. So it's not significant, substantial is the term. And by a matter of speaking, if your zoning allowed a 100-story building in this zone, and that resulted in shadowing of these properties nearby, because your zoning allows it, as a matter of law, that would not create a negative impact to the property owners because it's permissible by zoning. So because this is a completely by right application, there are no significant impacts, nor do I have to provide testimony even considering significant impacts because no variances are required.
I have a question. If we look at the conditional uses, and in particular, so this is 606 to D1J.
I'm sorry, 606.
To D1J.
Yep.
I believe. Should we just check that?
D as in David, correct?
Yeah, this is the definition of conditional uses. This is what we're talking about. So J specifies the minimum buffer to a residential use or zone shall be 25 feet. Now, I notice I'm not a planner, so bear with me. I noticed that every other specification of distance here either goes by the term setback or a frontage or a depth. But here we have something called a buffer, which I then searched the rest of the code and said, well, okay, I understand what a setback is. That's just a raw distance measured on a map. A frontage is just a raw distance measured on a street, and so on. But buffer is a unique term. And the only other place I can find buffers defined in our ordinances is in 609.3. And it says there, now, this specifically applies to a whole bunch of commercial zones and business zones, but it is defining a buffer. And the reason I think this might be relevant is because we're converting a residential lot in this neighborhood through the conditional use into a non-residential lot. So 609.3 says, whenever you have a development in any one of these zones, and I won't read them all out, but they're all commercially related, in which an application for development abuts a residential zone or use, a buffer shall be provided. No development is permitted in the buffer area. So there's a definition of buffer when you have a non-residential use abutting a residential use. So there's a very long preamble. My question is, do you think all the conditions in there that apply to a buffer between a commercial zone and a residential zone should also apply to the buffer between this house of worship and the adjacent residential zones? And if not, why not?
Okay, well, first to answer the question, it was already determined that by your planner that this provision of the code does not apply. So relying on your own professional, these provisions of the code do not apply to us. I do agree with you that the code is not clear regarding buffers overall. The only requirement of the applicant per your code is to have that 20-foot setback. And I mean, think 25-foot buffer setback, yes. But there's no standards that the applicant is responsible to comply with as to how that area is filled under your code, because there are no requirements for that buffer. Just thinking abstractly, codes aren't perfect. I represent towns. Codes aren't perfect. And you have to think about also that when you apply this code, you're applying it for all institutional uses in a residential district. You can argue, and that in residential districts, churches and schools were considered to be compatible. They weren't considered to be a land use that was going to be negative, particularly on 3-acre lots. These are very large lots. So your code required 25 feet, and specifically only applied it to where the buffer provision was. It only applied to commercial areas. So I can just speculate, but your code only requires that 25-foot buffer distance to the applicant. And that was determined, again, by your own professional.
No, I'm curious though, because you mentioned buffer setback, but it explicitly says a buffer. It doesn't say a setback. Setback seems to be just a raw distance. Buffer seems to have some other intent to the use of that area. And so I'm wondering whether these other conditions are all very reasonable. For example, fencing installed within the buffer should be set back from the property line at least 5 feet. Landscape screening should be provided between the fence and the property line abutting the residential use or zone. Trees and shrubs shall be planted between the fence and the residential line and should be planted in a zigzag pattern, not more than 6 feet apart at center. In the remaining buffer area, solid and continuous landscape screen should be planted, etc., etc. All loading areas and parking lots shall be buffered from adjoining streets, i.e. one of these buffers, not a setback, but a buffer. So it seems like that's a very reasonable requirement. It's been imposed on commercial zones, and I'm using your convention. I see it's -16, so I guess it was 2016, which is 3 years after the previous one. So it seems like this was a later introduction that probably should have been back applied to the conditional uses to say, one small footnote buffers as determined by this other section of the code. Do you think that's a reasonable interpretation?
Well, respectfully so, sir. This is not a requirement on the applicant per your code. And again, as indicated by your planner, if you're asking the applicant whether they would consider those provisions, that's a different question.
Well, that's my question. You as a planning professional, do you think that in this use it would be appropriate to consider those? I'm not saying, do you think they're legally required? I'm actually asking you as a professional planner, do you think it would be appropriate?
Well, there's provisions in that buffer ordinance that personally I don't think would be a better alternative. By way of example, it asks for a double row of evergreen trees, right? And that's, if anyone's landscaper on this, that's an alternating row of trees maybe staggered every 8 or so feet. And that creates like what I would consider a not unnatural look. In landscaping features, we don't see patterns drawn in perfectly straight lines, right, naturally. And that would be all evergreen. And the applicant has proposed a mix of evergreens and deciduous trees. So in one context, applying the standard in that code, in my opinion, would result in a less attractive landscape buffer feature than what's being proposed today.
That's fair. I wonder whether some of those features are designed to protect the adjacent residential property from the headlights of vehicles coming in. Because if we look at, let's see, all loading areas and parking lots shall be buffered from adjoining streets. And if you look at the definition of the requirements on the trees that need to be planted in the buffer area, no less than 20 feet high in maturity, that's fine. But the lowest branches shall not be more than 1 foot above the ground. Now, to me, that 1 foot above the ground implies, well, we need to buffer low down as well as high up, buffer in a general sense here, not in a technical sense. And therefore, that's a way to protect the adjacent residential property from the headlights. If you look on the plan, there's a strip of parking down that side, which are all at the top are within 25, well, very close to 25 feet. All the cars pulling into here, the lights are shining into neighborhood property. It seems to me that the requirements on those landscape trees, rather than just being an attractive feature, are actually designed to provide some sort of light restriction.
Okay. Are you referring to the parking spaces along the west end?
The western side.
That's what I was
Pointing west?
Pointing west, yes.
One of the conditions of approval that I offered up last time and reiterated this evening is to maintain a 6-foot-high solid fence along that western line and maintain it so that it's an effective visual screen.
But in that regard, if that fence may encroach into your front yard setback at 6 feet, that may create a variance. So it would have to maybe be staggered from 4 to 6 feet, not to create a variance. But my understanding is if you're suggesting that landscape edge is not providing that level of buffer to stop headlights, I think the applicant's agreeable to modify that area.
Right, I think, that's what I'm suggesting. That it seems like we want to consider the same considerations that went into developing 609.3 3 years after the conditional uses were defined. Would make sense to consider how they should have been back applied in this case, rather than just. I do recall the earlier meeting where it was asked if they would repair the fence. The initial answer was no, they weren't going to repair the fence even. And then next meeting we found there was a change in that position where they would repair the fence. So I think if we sort of carry that a bit further forwards, it's really that buffer with that westerly neighbour that's going to suffer the most from the traffic coming in.
If you ask me if I think it's reasonable to stop headlight glare on an adjoining property, I think that's a reasonable request.
Okay.
Well, to answer a follow-up question, is there, do you think there's any interplay between the required setbacks and the characteristics and design of any buffer? And what I'm driving at is here for the conditional uses, there are stringent setback requirements that don't apply universally throughout some of the commercial zones.
Just clarify, I'm sorry, Michael, I'm not really following you.
Just the required setback of the principal structure from the lot lines, greater rather than smaller, have, in your view as a planner, any influence on the nature of the buffer that would be appropriate, either its density, its height, that sort of thing?
Clearly, the further a building is from a property line, right, less noise. If you look at items in perspective, right, the closer an object is to you, the larger it looks. The further that object is away, the smaller it looks. So clearly, yes.
So I have a question. So going back to the DRZ 609.3 buffers. So while I understand that our town planner may have opined that he doesn't believe this applies, if we look at the actual text, I think it's a little bit less clear. So I have it in front of me. So section A of 609.3 says, when the property of a non-residential use, which this property is, it's a non-residential use, a multifamily housing development or any combination thereof abuts the R3, R4, R5, R6, or R7 zones, or a residential use on the side or rear, a strip of land should be designated as a buffer, so indicated on the plat measuring either 20% of the average width or depth of the property or 50 feet, whichever is less. Now, I think that "or" is really key here, because while it does clearly delineate certain zones, it also seems to say, or if it is a non-residential use, and on the other hand, you have a residential use on the other side or rear, then the buffers do apply. So to me, that seems kind of unclear. Now, you're a professional planner. How do you interpret that? And, you know,
In this case, I would respectfully disagree, sir, because a conditional use standard, if it's not applied to, we wouldn't even have jurisdiction here. We would be at the zoning board, right? So that's a very specific standard as to the buffer that's being applied to this land use. And because your ordinance was revised to specifically contemplate this use in a relatively recent period of time, in my opinion, that would be the prevailing standard that applies to this. If you want to say, hey, you know, we have no standards for buffering, and we'd want you to consider maybe some of these other landscaping features. I mean, I think there can be some interplay with the applicant, and the applicant can potentially entertain that as a series of goodwill. But that's really goodwill, I believe, because it's clear that it doesn't technically apply. I think it's clear that your ordinance is very clear that the buffer requirement in the conditional use section should be 25 feet.
Graham, do you want to?
based on my read of this, I don't know if that's all that clear, and I don't know who the judge of that should be, quite honestly. You know, whether that be you or our planner, you know, we don't know the intent, but the way I read it, I think you could see it both ways.
If I may, Mr. Chairman, the professionals that would opine with respect to same in this quasi-judicial process that the board would rely on or choose to rely on, if they so choose, would be the attorneys and the planners, in my opinion, and in my experience, and under the law. So you have two planners thus far. You might hear from more. You have an applicant's counsel. We know of one objector's counsel. You have a board attorney. Those would be the individuals who I would advise you to entertain with respect to an interpretive issue, as well as using your own judgment, particularly if there's a difference of legal and/or planning position. But certainly that would be my advice. I know it's fairly general and vague, but we're hearing from one planner. We've heard from our planner. We may hear more from all of the above and other planners. So onward.
Given that setup, Graham, do you want to explain maybe why you felt that it didn't apply?
Or concluded and opined.
Yeah.
Because with all due respect, our feelings don't dictate what we can and cannot do under the law. And this board's jurisdiction is legally prescribed.
So my characterization and review of the text, in my professional opinion, is that 609.3, the section buffers, contains kind of a preamble statement, which kind of sets up the parameters to which this section is applicable. And it clearly states within, and it lists all of the non-residential zones within the township in which an application for development abuts a residential zone or use, a buffer shall be provided. Then there's a series of subsections, A through F, which detail and delineate those circumstances and the buffer requirements of each. The section that Mr. Secmandi was referring to is subsection A. So really that overarching opening statement kind of sets the parameters as far as where this provision is applicable. That's the way that I read it in my professional opinion.
Can you be a little more detailed in how that led you to conclude, if I understand your opinion correctly, that it is not applicable to this application?
Sure, the opening sentence, which I can read into the record for 609.3 buffer, says within the CD, B1, B2A, B2B, B2C.
You're going a little fast.
Sure. B3, B4, OR1, OR2, OR3, and CMO zones in which an application for development abuts a residential zone or use, a buffer shall be provided. No development is permitted in the buffer area. That's the opening statement for this section of the
And
code.
the subject lot is not in one of the aforementioned zones that you just stated?
That is correct.
Okay. I'm sorry. Please continue.
Then the section, as I explained, contains a series of 6 provisions or standards, A through F, which detail the buffer requirements and situations where buffer requirements may be, handled differently based on adjacency or other use cases. But in my professional opinion, that opening statement sets the parameters and defines the zones to which these buffer standards are applicable. And this property, as located in the R3 zone, is not located within one of those zones defined in this section.
And can you explain then why subsection A includes additional zones, including the R3 zone, and why it is that the preamble more general governs and what that more specific in subsection A reference to R3 means within that context?
Sure. So the opening section for subsection A, which states when the property of a non-residential use, a multifamily housing development, or any combination thereof abuts the R3, R4, R5, R6, or R7 zones or residential use on the side or rear, it defines the buffer parameters. I believe this section is defining both the zones and the individual uses because, just as we're hearing this evening, there may be other uses located within residential zones. The R3, 4, 5, 6, or 7 zones may contain a school or a house of worship or another use, but the buffer standard is to be from that zone line, not just from a use that may not comport as a residential use.
And am I correct then what you're saying is, while there's reference to R3 there, the subject property from which a buffer must exist must be within zones CD, B1, B2A, B2B, B2C, B3, B4, OR1, OR2, OR3, and CMO, which are in the preamble, the general, which then you're saying governs the A through F, the subcategories.
Correct.
Okay. I wanted to better understand our planner's interpretation
And if
and
I
conclusion.
may, just to round out the sentence, because it does say or residential use on the side or rear, it's defining that because there may be a residential use that is located in one of these other defined zones. So if it's adjacent to a residential use that is in one of these non-residential zones, there may be conditions where that exists, a pre-existing house that now has been rezoned into a non-residential district. The intent of this section was to maintain a buffer from that residential use, despite the fact that they may be located in the same zone district.
Right. But again, your position is that the subject lot from which the buffer must extend, so to speak,
Must be located in one of those non-residential zones.
that are listed in the preamble.
Correct.
Even though it doesn't explicitly state that, correct?
I'm sorry, if you could speak it to the mic. I'm sorry.
Sure, so I'm saying, even though it doesn't explicitly state that, I mean, would you at least agree that it's perhaps not worded as well as it should be to make it explicitly clear?
I think to Mr. Ricci's point, there are always improvements that can be made in municipal ordinances. I think that in this case, perhaps it is not that clear. However, I would contend that that opening statement does a lot of setup to define the zones and also to which it's applicable for applications for development. So it defines the parameters to which this buffer situation applies.
In your opinion, if I may, with respect to a conditional use ordinance, is there a general understanding that if a condition is going to apply to a use to render it a conditional use, that condition, in essence, would have to be clear that it is applicable to that particular use in that particular zone to have the significant impact of rendering that use, a conditional use that violates a condition and warrants and requires a subsection D3 use variance from the zoning board of adjustment as opposed to a fully conforming conditional use approval from a planning board.
Yes, I would agree. The conditional use standard is really the higher level test that is applicable to this application.
In other words, it'd have to be clear to apply so that if it is unclear, the appropriate interpretation is that it does not apply, correct?
Correct.
Can I ask of our own planner pretty much the same question that I asked of the applicant's planner, which is the use of the word buffer in conditional use is distinct in defining this distance. It's not just saying there has to be. So my question is, how are we to interpret what it means when we say buffer there? To me, the only indication anywhere in the ordinance is what we see in 609.3. I understand it does specify a buffer that's half the width of the one in 609.3, but there are a lot of other conditions there that would apply if we interpret this as a buffer as defined in 609.3. So what I'm looking for is the definition of buffer, and I wouldn't be looking for it if it just said setback or distance or something that comports with everything else, but it's a specific use of that term seems to be a term of art that implies more than just a mere distance to the neighbor. And I'm particularly looking at things like, even E in 609.3 says the approving authority may consider the effectiveness of existing vegetation in providing the desired screening and may consider other factors which may alter the design of the buffer. It's really speaking to the fact that this buffer is designed to screen neighboring residential properties from a non-residential use. And therefore it needs to have more to it just than a mere distance. Would you agree with that?
I would agree with the characterization that a buffer and a setback are not equivalent, measures or metrics to which the application is to be reviewed. I believe that a buffer, we do have examples or simply related text, I would say, in this section of the ordinance. However, this is not applicable. But a buffer, in the planning, profession is a space to be kind of protected and screened and provide for some of that separation, with additional elements, not distance alone, to provide some of that screening effect. So, and I think that the applicant has provided some testimony related to that regarding the maintenance of the fence and incorporation of landscaping features that can support this characterization as a buffered area, rather than a setback area, as you indicated.
In your opinion, is what is being provided in that buffer area now under the plan sufficient to achieve the screening goals that are specified in 609.3?
I think, as far as maintenance of the height, the existing fence to be maintained is 6 feet high. I think that a lot of these provisions are to protect and mitigate particularly headlight glare, other, detrimental adjacency issues. So I think at the 6 foot height and the incorporation of, vegetative screening or, incorporation of landscaping in this space, it's meeting kind of the spirit or the intent of the buffer area.
Maybe switch back to the applicant's planner. Are there any other benefits of this screening in the buffer besides just headlights or light pollution?
Well, trees tend to soften out noise, right, would be a benefit as well.
Okay, and do evergreen trees, do it filter out the noise better than deciduous trees, or how does that work?
Well, I mean, I can't say I'm an expert in landscape planning, but if there is a material there, deciduous trees drop their leaves, if that material retains year round, clearly sound moves in a line of sight. So if there's something to block that line of sight, clearly it's going to provide some benefit.
So in the environmental assessment or the EIS, there was a statement for the noise study saying that the noise preliminary or primarily came from the streets and it was deadened by the vegetation on the perimeter. But now we're including traffic inside the perimeter. Do you think the evergreen trees placed at the back of the lot are sufficiently dampening the sound for the entire western side of the property?
Well, that's something that's outside of my expertise. It's my understanding the applicant agreed to comply with noise per the state noise code. And whether this was a development application or not, the applicant is required to satisfy the state noise code. So at any time, I'm not sure who regulates noise. It's the county or is it the town have their own health officer? At any time, the county health officer, if it's the county, can go out there with their decibel readings. And the applicant has to comply with that. We're required to comply with that.
And if I recall correctly, the applicant stipulated to a condition of a post-occupancy noise audit as demonstrative of that compliance, correct?
That's correct.
But as it pertains to buffers, so there is no noise requirement necessarily for buffers, but it is supposed to dampen the sound. So do you think that now with this added traffic that it provides, the current landscaping provides sound dampening, or has a sound dampening effect, or could that be improved?
I'm not a noise expert. The applicant has agreed to comply with noise at the property line. So I'm not really sure how else to answer that. There is a evergreen buffer planted in that area. If you want to suggest that that should be embellished in some way, I think that's a request that the applicant can consider. But other than that, I really don't have an opinion.
Yes, I would like to ask the applicant if they would look into providing better sound dampening and light dampening effects along that western border.
And
to provide a complete or a substantial buffer between the residents and the non-residential use.
And do you have any specific recommendations in that regard? Is it plantings, fence combination, or?
Yes, yes. Yeah, whatever it is to provide a substantial buffer.
Okay, I see that the area is largely already filled with material. The question is, can more material be placed there? I don't know.
More material or without too much harm, change it, right? We don't want to take down too many trees, but we do want to provide.
Mr. Chair, yes, we will undertake to look at that and see what we could do in that area that could that further bolster any noise dampening and light dampening features. By the way, like I said, that again, just to reiterate, that is the area where we've already agreed to maintain a screening fence. Well, is it fair to say that if landscaping helps to dampen noise, that a solid fence does as well?
Yes, usually the fence is just for my opinion as a planner, I go to a lot of meetings and is usually considered the most effective. But
Is a 6-foot fence adequate to shield from, the headlights of the cars in the parking lot? Understanding that some of the cars may be far back. What height do you typically see used as a buffer when you're using a fence as a buffer between a commercial and a non-commercial property? In your experience as a planner?
Considering the grade is fairly flat, right? When you have like shrubs, often like landscape design 101 would really place shrubs around parking lot. Those are usually 3 to 4 feet in height. 4 feet in height is, we all have cars that blocks the headlights. So a 6-foot fence, as long as there's no type of grading associated with that, will be more than tall enough to block headlights. I'm not the site designer, so I'm not sure if there's any significant deviations in the grade there. I don't think there are, but so my testimony would be if the grades don't vary significantly, 6 feet would be more than adequate.
I have a question. It could be for either planner. We're looking at, our ordinance and regulations. Is there a state regulation for conditional use? Are you aware of any state regulations or buffers on conditional use?
No, because we're a strong home rule municipality. So through the municipal land use law, the state gives those powers to the township.
And if I may, Mr. Chairman, and for the benefit of Board Member Canfield and all the board members and all the public, as one attorney amongst others and planners as well here, municipalities govern zoning in the state of New Jersey, strong home rule, 564 municipalities, each with our own ordinances. That is where, under the municipal land use law, aptly named, the governing authority, not from the planning board, not from the zoning board, but from the governing body, through the adoption of ordinance process, our municipal ordinances govern. There is not a state zoning act other than the municipal land use law, which gives it to the municipalities in large sense. There are no state conditional uses or standards. We, as a municipality, like every other municipality in the state of New Jersey, get to govern the zoning within our municipality. Unless we are preempted by certain state laws in other areas, that's not the case here. Other than there is a federal RLUIPA statute, which has an impact perhaps, but aside from that, so it's municipal. It's our ordinance. It governs. If it's applicable, it's applicable. If it's not, it's not.
I was just thinking with the confusion of how it was written, that there was some guideline by the state as to how it should be written by conditional.
No, but there are principles of statutory construction that apply to ordinance construction, and some of those were shared by Mr. Petto, our board planner, with respect to how he interprets the ordinance and why he interprets it, in his view, as clear that it does not require, does not apply to this application on this site, and therefore does not render this a D3 conditional use application that violates one or more of the conditions of the use, but actually is a fully conforming conditional use, hence a permitted use, and therefore we, as a planning board, have the jurisdiction to hear it is as a fully conforming conditional use. Those principles exist in statutory construction. They come down to municipal ordinance construction, because our ordinances effectively are statutes at the state level, ordinances at the municipal level. That body of law exists. Mr. Petto applied it into his ordinance construction. I cannot disagree with it.
From a legal perspective.
From a legal perspective, he says it, I guess, from a planning perspective.
Thanks.
Sure.
Any other questions from the board? I'd like to open it up to the public. Are there any questions for the public for Mr. Ricky?
Hi, good evening, Mr. Chair, members of the board. My name is Nicole Dory. I represent Sustainable Development for Millburn Township. Can you hear me?
A little closer, maybe, if you could, for the.
Okay. So I have some questions. Mr. Ricky, hello.
And I'm sorry, again, you're representing, so for the record.
Yes, Nicole Dory, Connell Foley, on behalf of Sustainable Development for Millburn Township. I just have a few questions for Mr. Ricky. You mentioned that you reviewed the application materials. Did you also compare the site plans and the submissions to the township's ordinances when you reviewed the application?
Are you asking whether I conducted a full zoning review?
Yes.
Not a full zoning review. That's the burden of the township. I checked to ensure that the conditional use requirements, that we adhere to those, to make sure we have jurisdiction at this board.
Okay, so you didn't review the application to see if there were any variances or design waivers other than the conditional use?
I did not,
standards?
not in fully. I looked at certain areas of the code to make sure I agreed with certain interpretations that I heard from our attorney, but that's not my responsibility now.
Okay, and did you visit the property?
I did.
Okay, and you mentioned, I wanted to ask about the buffer requirement in subsection J.
Let me take my.
Oh, sorry.
I may need that.
Sorry to cover it up. The text there in subsection J says minimum buffer to a residential use shall be 25 feet. Um,
I'm
so,
sorry, you're in 606?
yes, 6062,
Right,
I think it's D1J.
D1J, yep, okay.
Okay. And so that term buffer, do you have a planner and understanding of what that means?
It varies from town to town based on how it's typically defined. We're at a loss here in Milburn because it's not defined.
Okay, and would you agree that the planning board, this board has jurisdiction to interpret its own ordinance?
Within reason, I don't think they have the ability to write their own definition of buffer that was not handed to them from the governing body.
And who do you think is to determine the adequacy of the buffer for this application, given that it's a conditional use standard in subsection J?
I believe it's the zoning officer and the planner. But given the fact that the only standard is to meet the 25-foot setback, and we meet that standard, there's not a lot to discuss, I don't believe, in terms of compliance or non-compliance. And it's not to say that there aren't plantings in that area already. It's already a fairly densely planted area. And the applicant has already agreed to look at it and to further embellish and to make it better. And I don't think that's, from a technical standpoint, an obligation under the code that the applicant's required to, but I believe the applicant has agreed to try to be a good neighbor.
Okay, but the subsection J, my question was that, would you agree it would be the planning board that would turn in the adequacy of the 25-foot buffer in this case? You used the word setback in your answer, but it's a buffer, right? And there's a distinction.
Yes, but the only requirement is that setback for the buffer. And the buffer is not defined.
So is it your testimony that in this case, because buffer is not defined, that it's the same thing as a setback and the applicant's not really required to provide any type of landscaping in the buffer area?
There's nothing in the code that specifically requires how that 20-foot buffer area is required to be treated.
Okay, and would you agree that even though perhaps if the other sections cited 609.3 doesn't specifically apply to this zone, that the planning board could look to that section of the ordinance for guidance to determine what a buffer should be in this circumstance?
Relatively speaking, with any except if the area of that code is in the conditional use section where the 25-foot is required, in my opinion, it's 100% clearly not applicable. Even though it's not applicable, it should not be considered because it's superseded by the conditional use standard. If you want to ask the applicant to consider applying some of those other standards, ask the applicant. I don't believe they're required to. You can ask the applicant. The applicant has already agreed to embellish that area. So I'm not sure what we're really discussing because he's already agreed to look at it and to make it better.
Well, my question to you is I'm trying to determine how you determine the adequacy of the buffer, because you're the witness of
Yeah, I can't because you have no standard for it. I can't.
But you're
Excuse me, everybody, please, unnecessary. Thank you.
So is it your testimony that the applicant doesn't actually have to provide anything in the buffer? Or what is your testimony about how you evaluated the adequacy of this 25-foot buffer, which is a conditional use requirement? I'm trying to figure out.
Simply stated, I ensured that a 25-foot area that was unencumbered in any way exists in that area. So based on meeting the 25-foot standard, they meet your code requirement. Anything else that's placed in that area is a benefit to the property, the residents and the like, but it's not a requirement in the code. Subject applicable to this application.
Okay, I was just trying to clarify your testimony. So is it your you reviewed the site plans and determined that because there was a 25-foot setback, that satisfied the 25-foot buffer requirement?
Absolutely, yes.
Okay, and so your opinion is that the applicant's not required to put anything, any landscaping, any fencing or other kind of buffering in that 25-foot buffer area?
There's not a specific requirement in the code requiring that.
Okay, and so if this board imposed conditions to require additional landscaping or fencing to provide an adequate buffer in that 25-foot area, is it your testimony that the board would be exceeding its authority?
That's somewhat of a legal analysis, and it quite may be so. In that regard.
I just wanted to go back to my original questions, which is because there's no other section in the ordinance that defines what a buffer is. Would you agree that the board could consider this other section, 609.3, to determine the adequacy of the buffer for this application?
Again, you keep asking me the same question. It doesn't apply. The applicant has agreed to look at it and to, for lack of better words, make it better based on the board's recommendation already. So we're functionally achieving the same purpose, because while it doesn't apply, we're still looking to make it as good as possible, for lack of a better word.
And do you know if the applicant will be submitting revised plans to the planning board so that the planning board can evaluate whether the changes that the applicant has mentioned during this hearing that it will provide, so the board can consider and the board's professionals consider if that provides an adequate buffer to address the board's concerns?
I mean, I haven't had a chance to speak with my client to even set me, so we would look at it, and I think we'll, like we have with a lot of requests, we've done that in good faith and in many instances implemented those requests, but I can't commit one way or another simply because I haven't had the opportunity to explore it with my client and our expert that puts the landscaping plans together.
And what else did you do to review the buffer that was proposed by the applicant? Did you discuss it with the engineer or the landscape architect?
I looked at the landscape plan.
You just looked at the landscape
Yeah, I
plan?
reviewed it. I'm a planner. I review applications. It largely consists of evergreen material, arborvitae in that area. There's some deciduous trees, and it's a mix of materials. So it's, I looked at the quantity of plantings on site as well, which I thought for a 3-acre site to be significant. What did I say in my testimony? Over 80 deciduous trees, over 80 evergreen trees throughout the site, and over 150 shrubs. That's significant.
And
there's trees out there as well. It's not like this is being clear cut, right? So there's other vegetation that's there as well. So at some point, there's not enough space, right? And if someone wants to have a little bit of a lawn area, that's their right too, right?
But would you agree a buffer is not a lawn area, right?
Based on the code, there is no definition. So a buffer could be a separation, right? It could be a fully planted area. It could allow for different types of elements in there. We can have fountains and water features. It could be a lot of different things.
Right, and these are all considerations that the board would decide. Do you agree?
No.
So who would determine what would be located within the buffer, in your opinion?
It's my recommendation that moving forward as a planner, that the township evaluate its buffer requirements and update its zoning ordinance, because for an application like this, it currently doesn't have any. So I can't suggest what something should be if I don't have something to review. I can't say it's adequate or inadequate because there's nothing to review. There's no standard. I'm not sure how many more times I can say that. I'm sorry.
No further questions.
Excuse me. My name is Jeffrey Feld, 11 Alexander Lane, Short Hills, New Jersey. This goes back to the purview and the jurisdiction of this board. You say you were involved in the original application that was filed in May of 2024. Is that correct?
I was called to represent the applicant. I'd have to check my proposal and the like, but early on in the application.
All right. Did you review the notice that was issued for the first hearing on the application?
I did not know.
You were not involved?
With the notice? No, that's
No.
illegal.
So it's legal. Were you involved, we're talking about conditions, were you involved in reviewing the coverage ratio issue?
No.
No. All right. But you said you looked at the ordinances that were, and memos provided by Graham. When did you review a memo? When did you start reviewing the memos reviewed by Graham?
I mean, I received the memo. Let me pull it out.
Which memos? There's memos.
I focused on his latest letter. I mean, I've been a part of this and I've been reviewing the letters as they've been sent to me. I don't have exact dates for everything.
All right.
And I've been at the last 3 hearings, and I'm just gonna say a couple things here.
All right, sure. Speak to the board.
This application is reviewed by the township and its professionals as to the adequacy of the ordinance, right? It's not my job to do a whole review of the zoning ordinance and say, we meet every requirement. That's the municipality. That's why we get a letter from the planner and the engineer and the like. And when issues come up during the process as to interpretations or whether something applies, we had the issue of the buffer, whether the infiltration basin should be considered as part of that. I recommended to my client to remove it, to take out any question of that being an impact in the buffer. So, the township has excellent resources that are reviewing that portion of the application.
So I want to understand this. So you're shifting the responsibility of the jurisdiction blame
No.
to the
No.
the planner over here?
No, they reviewed the jurisdiction, right? I was asked to review the jurisdictional conditional use standards, and I agree that this is appropriately placed in front of the planning board.
Question, when did you learn that there was going to be a daycare center as part of this application?
I don't know the exact date. I don't know.
Was it in May?
I don't know.
Was it in September?
He said he doesn't know.
I don't know.
You don't know? Is God coming?
Was
in
that
there?
the
I know that.
dramatic effect, Mr. Feld?
No, like the wall of Jericho coming down now, or what's going on?
Maybe you want to continue.
No,
I think
continue.
He asked and answered the question.
That he does not know.
I think we got.
The cover ratio. Now, when you started looking at Graham's memo that was from January, when we talked about coverage, and when you looked at all these site plans, did you notice that the playground was not included? That impervious uses there's a difference between pervious and impervious uses. Why were impervious uses excluded from the coverage ratio?
He's asking a planner to speculate about why numbers were included or not included on a plan that he didn't prepare and didn't testify to.
If I may, if I recall correctly, that was changed, amended,
Right,
and
4
even
times.
assuming arguendo that the playground was impervious, the applicant has contended that they meet the lot coverage ratio. Is that correct?
Yeah, and that's a perfect example of what Mr. Ricky was mentioning in terms of the board having tremendous resources at its disposal. Mr. Petto actually is the one that identified the fact and the subtlety in your ordinance that by virtue of the playground area being an accessory use, that counts as impervious coverage regardless of whether it's grassed area, whether it's wood chips, still strictly speaking. So he brought that to our attention. We had to address it.
So, Mr. Feld, do you have questions that are material or even relevant to the pending application?
Yes, I believe I do have
Okay.
stuff that's
Please
relevant, and I
continue.
do
Please
appreciate your
continue.
comments on this, because it goes to the jurisdiction.
Right.
Now, we heard before, it was the legal attorney and the planner that signed off on the jurisdiction. One
No,
on the
no, I
notice
didn't sign off on the jurisdiction. The planner did.
about there's 2 parts of jurisdiction. One is the notice, whether that
That I
applies
opined, yes.
about procedural due process, and that's the state constitution,
Right.
and it's not about state rights. The next part goes back to the coverage ratio. And there's been issues about the coverage
Mr.
ratio.
Feld, you're
Right, here's,
incorrect.
I have one more question.
You're incorrect in your statement, though, so it's important that the board understand. The notice is the jurisdiction pursuant to the notice is defined by the municipal land use law, the requirements under section 10,
Yes.
and applicable case law, including the Pearl Mark case, the Pond Run case, and their progeny.
Yes, there's
and
a lot of
some their
progeny.
ancestry, but the as well. So it is not purely states' rights, this or that. Candidly,
All right.
I don't know what you mean by states' rights, but I don't want anyone to confuse the board as to what jurisdiction is and isn't. It's governed by the, and I would have brought it up if you didn't, but you did, and it was incorrect, so it's important that I correct it for my board.
I think there's some
so
other
that
case that
they-
came
so
out.
that
We'll have
they-
a-
Mr.
we'll have that
Feld, I'm not
discussion.
done. So that they decide this case properly.
All right.
Because that is my job. That is why they retained me.
All right.
And so I'll finish. Thank you.
All right.
It's defined by the municipal land use law, and it's defined by the case law under the municipal land use law, which defines what notice must have as far as content, time, date, place, the general description of the application and what is involved, the nature of it, and date, time, and place. It must be properly served, etc. That is by municipal land use law statute, section 10 of the municipal land use law, 40:55D-10, and the case law, the Pond Run case, the Promart case, and several others. That is what governs.
We'll discuss that later.
Now that my board has been properly advised by their board attorney, please, with
All
the
right, I
chair's
just-
permission, please continue.
The only other question I have, you said you're a planner, and you're talking about sidewalks. What is the required width for a handicap sidewalk? Is it 3 feet, 4 feet, or 5 feet?
I believe it's generally 5 feet, but
Thank you.
Hold on, Ms. Best.
Charles Bambara, 37 Keats Road in Short Hills. I have one question. Could you explain the discrepancy in your testimony where you referred to the application as a house of worship and the applicant in his testimony under oath described the majority use of the property as a daycare and preschool? I'm confused.
okay. Well, I think this is under case law, right? This has gone to court whether the childcare is a second use, and I believe I can probably look in my notes. There's at least one case that I'm aware of that is determined it to be an accessory part of a house of worship, and it's not a second use. So it's permissible. I mean, land use, the way of explaining it is a process that evolves over time, right? And when there's precedence of something occurring over and over again, it's usually accepted as being a permissible portion of that use. So the courts have already determined that daycare is a permitted accessory use associated with a house of worship, and it's still considered one use of the property, and it's permissible.
Okay, thank you.
Ms. Best?
I'm good.
Okay, Christine, do I have to say my name again?
Yes.
Christine Best, 15 Fairfield Terrace, Short Hills, New Jersey. When you were reviewing the variance needs on this property,
Variance needs? Variance needs?
you reviewed the variance needs as part of the planning process, determining to your client whether he would go in front of zoning or planning, correct?
I reviewed the conditional use standards. If conditional use standards aren't adhered to, that's a jurisdictional issue. And I was here for the testimony for several hearings when the issue of whether we were over the impervious coverage or not, I listened to that testimony. So based on, I think, what Mr. Petto said, the issue arose and then the applicant instantly corrected it because that was something that was never raised to the applicant from point one in time. It was never determined to be a variance. As soon as it was determined, the applicant instantly rectified that condition. Because you have to understand that as well, we're giving letters and reports and we try to address those. And if something's not raised to us as professionals, we can't either fix or make better or understand what may be an ordinance. I'm kind of speaking too much. I'm kind of, I guess, speculating your question, which is not.
Yeah, I wasn't finished.
But I'll stop.
It's okay. No, it's okay. There's just multiple parts. So there's a couple of ordinances that I'm not sure if you reviewed them. The first one is 24-17-13, and it's in regards to, it's in regards to, it might be, it's 25-95-21. It's in order to protect, I took an excerpt from it, In order to protect the health, safety, welfare, and residential character of the township, the placement of any decks or platforms, can't be done on a rooftop. So that's a new ordinance that came out, I don't know, maybe in 2021. So in order for you to put all your rooftop equipment on, you would have to place some type of sound pad or decking to accommodate that. So if you can't do that, are you going to pull all of the air conditioning units off, the rain collection system, possibly a generator off the rooftop, and then would you have too much impervious coverage and need to apply for variance? And there's another law that would pertain to that question as well.
First of all, I'm not very clear of that provision of the ordinance. I'm not sure if I can answer the question. Is it speak to like residential decks? What is it?
No, it's just about rooftop decks. It's a new ordinance that our township committee.
Do you have a copy of the ordinance?
I was reading it off the E-code, so I don't happen to have a copy of it. You can look it up on E-code. But there was also another ordinance that would pertain to this. It has to do with accessory units such as air conditioning and other things like generators. And that's under 2416-13 and 2471-16, specifically talking to 609.1D. In Milburn, AC units are only allowed in rear and side yards, and they must be screened by either a fence or some type of screening, sometimes noise screening, and evergreens. And also in 609.1F, the same should hold true for a generator. So they have to be in the rear or side yards. I'm trying to understand how they can be in the sky, how that would apply, and would they have to go back down on the ground?
That was addressed by I didn't want the first question or the first ordinance, Ms. Best,
Right.
you referenced to fall through the cracks.
Sure.
And Mr. Powell, maybe if you could have, I seem to recall in reviewing the ordinances, and, correct me if I'm wrong, but my recollection is that the rooftop decks that were the subject of a recent ordinance have to do with rooftop amenities, where people are invited to go and congregate there and either sit or it's more like a public amenity space as opposed to utility style decking on which, mechanicals. Am I correct about that?
That's a correct characterization, yes.
So are you saying, Graham, that particular ordinance would not be applicable here? Is that correct?
That's correct.
Okay. And which ordinance again was that, Graham? Or
I think it was either 2595-21. I don't know why I wrote 241713. It's either one of those two. But thank you, Deborah. I think that the language is somewhat vague and confusing. That's my opinion. I'm sorry not to say that, but.
okay. These ordinances all relate to each other. That's why there's attorneys and planners that interpret them, and it's part of a statutory construction, the entirety of it. So, but if you're picking out certain individual ones in isolation that you think might apply, you may be correct, you may not. We'll find out.
I'm sorry, go ahead.
Ordinance section 609.13.
609.
The 609.13 is the ordinance section.
Is where 25-9521 ended up when it was codified? Okay, thank you.
And does Grant have an opinion on the AC and accessory use things on the roof in terms of in residential areas? Do you have a point of view on that?
Is it applicable?
I think it's applicable because then
but we're trying to find out from our planner, I think was the question by the chair.
He was looking
as
at
to
me, I'm
whether it
so
was
sorry.
applicable. In his opinion.
Is what applicable?
The ordinance?
This section of
Yeah, I was talking about 609.1D and 609.1F off of, I believe it's ordinance 2416-13 and 2471-16. It's in regards to AC units have to either be in the rear or side yards and must be screened by either evergreen plants or some type of screening system. I was trying to understand how rooftop uses, that can be allowed. And I would have loved to put mine on my roof. I was just wondering.
So section 609.1.
D, 609.1D and 609.1F refers to the generator and 609.1D refers to the AC units. And I don't think I'm assuming that the collection, the water collection system would also fall under accessory use.
My suggestion with respect to subsection D is that air conditioning units may be placed in rear or side yards. It's not a shall, it's not a compulsory requirement, it's an optional requirement. Those will be located in those locations.
Oh.
Can I speak to that?
Oh,
Can I say something? Or let me say.
It says air
Wait, everyone can't speak.
They're, one at a time, and I don't, candidly, if people are gonna throw up in isolation ordinances and throw them at the planner and say, what do you think about this one, what do you think about that one? They, in fairness to the planner, it would be fair to give him, at a minimum, a fair amount of time to consider the ordinance in connection with this particular application and how it may or may not be applicable. And with all due respect, and certainly the board members, should ask questions of the planner, but the firing line before he has an opportunity to review it, to make a professional determination as a planner as to whether it's applicable or not, really should come first. And then if you
I understand. There's
have
one word
questions.
missing though. It says air conditioning units may be placed only in rear and side yards. So that's a little different. That controls over the mass.
Right, and I don't know, is it applicable to this zone, this use in this zone? We have to make sure that we don't rush
No,
them to
I
make the
understand your
wrong,
point.
wrong decision.
I just wanted to say there was one word that changed the meaning of what that says.
I think the characterization is that it's characterizing, the overarching section 609.1 is accessory uses in residential districts. So an air conditioning unit, when ground mounted and not affixed to the dwelling or to the building in the zone, would be considered an accessory structure, which is separately ground mounted. So that's why there's standards that are applicable to this. If a mechanical unit is affixed to the building, it becomes part of the principal structure and is subject to principal structure regulations.
So then is it your interpretation as a professional planner and the planner for this board that that provision is not applicable here because a roof-mounted unit or units are permitted? It's only applicable if they are ground-mounted and not roof-mounted.
Right, yes, that's correct.
And I'm just trying to understand his interpretation. So,
I understand. I hear what he's saying.
okay. We want to be careful to get it right, not wrong.
Thank you for the extra time.
Sure, well. My loquaciousness will buy you some time, that's for sure.
So is there a code, is there a specific code that you're speaking to in our township code?
I think he just analyzed the one
He
you
just said
gave him.
character.
He just interpreted the one
Okay,
you
I
gave
thought he was talking, well, he actually talked about something different. He didn't specifically say that,
He
but
said
that's
it
okay.
became part of, it becomes part of the building, essentially.
Yes, so it's interpreted, okay. So I wanted to ask you in your opinion, do you feel that deed restrictions supersede zoning laws?
If there's a deed restriction on the property that restricts this property in some way, I mean, that's something that's usually submitted at the initial part of an application. So that could have implications on an application.
Mm-hmm. And I mean, in some states and counties, oftentimes in a situation like this where there are existing deed restrictions that intend to develop a neighborhood scheme, I was going to ask, will the applicant, or can you ask the applicant if he can confirm and or acknowledge that there are deed restrictions on this property, and if the development is later found to be in violation of that he won't hold the planning board accountable?
There's a lot going on there. First of all, the board enjoys broad immunity from suits by applicants before it with regard to the actions it takes under the municipal land use law and processing land development applications.
Thank you for putting that on the record, Mr. Lee, and I concur with that. That is true. That's a fact legally.
Secondly, Mr. Ricky's right in that.
You can relax a little more now.
Part of the completeness requirements that we adhered to when we initially submitted the application was to provide a complete copy of a title commitment and title search that shows all of the recorded easements and encumbrances and restrictions of record against the property. That's on file. It's been on as part of our application since day one. Also, and this goes back several months though, there's also been some testimony and some dialogue before the board with regard to this issue of deed restrictions. It's actually been the subject of an appellate division case, and this litigation actually analyzing and interpreting these deed restrictions as submitted by a judge. But setting all of that aside, there's case law in New Jersey that makes clear that the land use restrictions and deed restrictions are matters of contract between private parties. They kind of operate on separate, parallel, but distinct tracks. Planning board's job is to interpret and apply the zoning ordinance and grant site plan approvals and subdivision approvals and what have you. It's not within their purview to interpret and apply deed restrictions in recorded documents.
If I may, Mr. Chairman, I recall the case of Klein versus Bernardsville as one that comes to mind. For example, if there is a deed restriction or easement that has an impact on a development, it is beyond the planning board's jurisdiction. In essence, even if it was applicable and had an impact, we would decide separate and apart whether or not, based on the law and the evidence before us, I say us, I don't vote, whether or not the applicant met their burden and was entitled to relief. If in fact there was something, a condition or a deed restriction, et cetera, that would impact that and prevent them from developing, it's beyond our jurisdiction. Our approval would be conditioned on compliance with law, all laws. They'd have to deal with it, so to speak. If it's not applicable, obviously it has no impact on them. Those matters are matters of contract, and they can either be resolved by the parties to the contract or by a court of law. We're quasi-judicial, but we don't get the robes. He's got the gavel, but we don't get the robes. So we are subject to the law. So that would be determined subsequently if and when necessary, if, as Mr. Levine is contending, that a court has already rendered a decision on it. If that is correct, then we have to abide by that decision. We cannot differ from that decision. But again, whatever we do, it is conditioned on the law and any law that was already established, including court order, and any law that is subsequently to be established for matters that are not already resolved. So in essence, it's outside of our jurisdiction completely, whether it's, even if it's applicable, even if it has a material impact. We can't decide that. We only decide what's within our jurisdiction.
So that paperwork around the deed restriction was part of the application simply for our information, but not for our consideration? Is that what?
Well, it's to, applicants generally must provide, or they should provide, in my opinion, title history to demonstrate that A, they have standing. Are they an owner, a contract purchaser, have some sufficient interest in the subject matter of the application, the land, in order to be able to bring the application in the first place. There are a variety of things that come from that information that is relevant. They may take the position that based on what's here, there are no encumbrances, no deed restrictions, et cetera, legally that impact them. But whether there are or there aren't, ultimately is beyond our jurisdiction because we have to leave that to the courts, in essence. I'm summarizing, but that's how it works, so to speak.
So are you saying then that we would make our decision and then that would be a separate action to deal with the deed restriction, perhaps?
If it hasn't been, if it's applicable, if it's relevant, and if it hasn't already been resolved, then certainly someone might bring it. The world is dynamic, things happen every second. But I'm sorry, so please continue.
It's a very important thing that you said, Mr. Warner. I wanted to, because some of the comments came from your attorney, not your attorney, but the attorney, I wanted to ask, did you advise your client of the New Jersey Appellate Court that held that neighbors can enforce deed restrictions in Sherry versus Ziad Hadaya in 2021 for Princeton, New Jersey?
I did not.
So going to historic resources, is it in your opinion, you talked about originally all the conditional use, bullet points, setbacks, all very, very logistical metrics, right? So there's also part of the master plan, and in one of our township documents that was adopted on February 6th in 2024 as an amendment, it's ordinance number 2658-24, ordinance amending and supplementing the Township of Millburn Development Regulations and Zoning Ordinance. Under here, I can just show it to you right here. It's on, page 3. It talks about definitions, and one of them is historic resources. So there's a difference between something that's designated historic or designated in historic district versus identified as historic. And so this property, 165 Old Short Hills Road, was identified by Barton Ross as historic, potentially historic on the master plan. And so it is considered, as our definition in our code, a historic resource. Does your client know that?
I don't know, but I don't agree with that opinion.
It's not an opinion, it's a stated fact in the
Well,
law.
ma'am, it's subject to interpretation. I
Of
think
course.
Mr. Levine may have already made a contention with respect to the applicability or lack thereof of where it fits with respect to it being potentially a potential designation as referenced in the historic preservation element of our municipality's master plan. But attorneys may argue, planners may argue. Did I say attorneys may argue? We know attorneys will argue, right? But please continue.
Okay, I'm getting close to finishing. Did you have something you were saying? I'm sorry.
No, I'm just responding to your questions. I just disagreed with your statement, that's all.
Okay. So you also talked about, again, that, in your opinion, that the installation of such a development would promote significant benefits to the town, which I'm sure there's going to be a lot of benefits in a lot of ways, a lot of pros, and then there's also going to be a lot of cons for local residents. And so, the planning, is it, in your opinion, the planning board, while they have to look at all the conditional use applicable points, the whole point of the planning board here is to evaluate whether something becomes, a public nuisance because of traffic, also with light trespass, et cetera, and noise, and is it beneficial for the overall community that's living in that region?
I completely disagree with your statement. And I was very clear about this in my direct testimony. I discussed the Pizzo-Manton case that said when there's no variances, and I can repeat my testimony.
No, I remembered that you talked to Pizzo-Manton case, but I'm just specifically asking that question.
No, I think the courts are very clear, and I respectfully disagree 100% with that statement.
And then you talked about, I think, was it 83 trees were being planted? That there. Am I misquoting you? I don't know.
Yes, I indicated that. Give me a second.
Thanks.
There were over 80, as I counted on the landscaping plan, which is right here if you want to look at that.
Yeah, I looked at
I counted, by summing up, if my math is well, 83 deciduous trees, 86 evergreen trees,
it was 86,
and
I'm
150 shrubs.
So did you know that some of the trees of the 86 that have been requested to be planted or being claimed to be planted are currently have been planted and are 1 foot high, and then right along the roadway on 165 Old Short Hills Road? Do you think that 1 foot high trees meet that criteria of
I don't know if that's accurate, first of all.
It's,
Wait.
I think the township forester told me that
Ma'am,
information.
and Mr. Ricky, Mr. Chairman, with your permission, the process is question by questioner, answer by witness. Witnesses cannot consult in answering questions with other individuals. That's not a proper procedure, in my opinion, in this quasi-judicial process. So if you know an answer, you know an answer. If you don't, you don't. If you think you do, you decide how you're going to answer, but it's question and answer by questioner and responder.
Understood. I don't know if that's accurate, because when I was here, there was some discussion, I believe that Ms. Canfield raised some issues associated with trees being removed, and the applicant confirmed that those trees weren't already taken down. So my understanding was, at least what I heard through testimony, I'm not the landscape designer, that everything on this plan was new plantings at the proposed sizing indicated in the plant list on the site plan. That was my understanding.
Okay, so those little tiny trees that go along it will not be part of the 86 fir trees that go in, correct?
Well, the applicant, based on their submission, is required, because this is what they submitted, is that the size of the trees are all 3-inch minimum caliper. And again, I'm not a landscape expert, but usually, it's a tree that's maybe 12 feet tall or so. And then the evergreen trees, because deciduous trees are usually by caliper, right? That's like at the breast height. And then evergreen trees are usually measured by their, from the base to the top.
Right.
And the applicant indicated that those will be installed at a height ranging from, it varies, some are 6 to 7 feet, some are 5 to 6.
Okay. So those just must be extra trees. Okay, that's cool. So I guess the last question that I wanted to ask, and I may be repeating myself, so you happily tell me that. So a planning board can, on a conditional use application, deny an application, the applicant fails to demonstrate how proposed use will mitigate potential negative impacts and does not meet the specific conditions outlined for conditional, well, I know that part, or that part's already set, or if the project is simply not compatible with the surrounding area. Do you think that's untrue?
I was very clear about this, right?
I'm just
I spoke
rephrasing
about
it.
This has no negative impacts because it complies with your zoning ordinance. There's nothing to even contemplate here. If there was, just say there was a variance here, and I had to testify to the appropriateness of this, I may look to the character of the area. It depends on the type of variance. I may look at whether the benefits of the variance outweigh the deviation and the totality of the application. I also may look at other similar uses and how they've been applied throughout the township. Because when you zone, a community has to give, under the law, a reasonable consideration to the existing character of the area. So I would analyze the character of the area as well, but I did not have to do that here because none of those variances were identified.
Thank you so much. Have a nice day.
Anyone else from the public have questions?
Yeah, Ted Cohen's in Short Hills. Just a couple of quick questions. I just got a little confused on the difference between the setback and a buffer. I know we've gone over this, but for my clarification, I'm sorry I'm asking it, because I thought for a commercial property, is a setback required? Is it different than for a residential property?
Well,
a setback.
I
don't know if you're using them interchangeably or not.
The setback under the code, the distance between a street line or lot line and that portion of the lot where structures are located based on the setback requirements of the ordinance. All setbacks from public streets shall be measured from the proposed right-of-way or as shown on the official tax map. Roof overhangs may project a maximum of 2 feet behind a required setback line, except as otherwise provided in this ordinance.
Okay.
So that's
got it.
definition of setback.
Got it. Okay, so it just refers to the building itself, not the parking lot.
Well,
The
there
setback
are,
does not
it
parking lot
does,
It
because
does.
there are separate standards.
Gentlemen, one at a time, or else it'll be difficult for him
Oh,
to
I'm
transcribe.
sorry.
But
I'm
also, it might be construed as argumentative.
Oh, I'm just trying to clarify. I don't
Right.
understand the
One at a time.
definition. Okay.
I'm from New Jersey, I speak quickly.
I think most of us.
I know, we're all are.
Well, the code also has parking setbacks as well. So there could be a setback applicable to a front yard, side yard of a building, and there could be a parking setback. So it depends on the code.
Is it different for residential and commercial?
It
Because
can be,
if this is a
yes,
commercial
yes.
property, is
But
it meeting
it's-
the setback requirement
For what specifically?
for the parking lot?
Yes,
It does. Okay, okay. And
because that setback is required to be 20 feet.
20 feet. We had some, I was confused. I heard 50 feet and I wasn't sure what and that's for a commercial property,
I
right?
believe Mr. Sacamandi, if I pronounced that correctly, was referring to buffer standards.
So I was,
Um,
I
yeah.
got the buffer discussion. I was just wondering about the setback discussion.
Yes.
It's because you're using them kind of interchangeably. I got a little confused myself. Okay, so you're claiming that the parking lot meets the setback requirement for a
Correct.
commercial building?
Correct.
Okay. Just one other question. Would you, given with the nature of this project, a lot of school activity there, would you recommend that there be a school zoning, driving on Old Short Hills, making it a school zone for safety purposes? A safety issue came up for children. Would you recommend they put in a school zone?
That's outside my expertise. That might be a question for an engineer or a traffic engineer. I don't know, sir.
Okay. So projects you've seen with like this, would they?
I don't know the criteria that's established or when something
for
is
requiring a school-
requires.
a school
It's
zone.
outside of my expertise.
Okay, question I have. Okay, thanks.
Mr. Chairman, if I may, just as kind of as a follow-up, in furtherance of that issue that gentleman just raised. Paul, do you have an opinion as a planner, looking at the specific conditional use standards for a house of worship? It's interesting, there is a 25-foot buffer to residential. There's also a 20-foot setback for parking.
Yes.
So with those two things being simultaneously true, do you feel that this applicant or any house of worship in compliance with those conditional use standards would be permitted to park cars up to 20 feet from the property line and thereby being 5 feet inside the buffer?
No, but I think the buffer would prevail here. We'd have to meet that 25-foot setback. Because in this context, if they're both, the buffer setback would be the prevailing requirement. Because if you can't, while there's no standard or a definition for a buffer, if you even applied your definition of setback, that would be encumbering that requirement. So I think it would have to be the 25 feet.
Mr. Beck, could I ask, do you have any thoughts on that issue?
Concur with Mr. Regents.
Great, thank you.
Any more questions from the public? Any questions from the board? Is there any, Mr. Levine, do you have any more witnesses?
No, I don't have any additional witnesses to present or introduce to your folks. I would just, I realize that their objectors may put on direct cases and members of the public may as well. So just as would typically be the case, I'd just like to reserve the right to recall my witnesses to provide additional direct testimony as may be needed. But I don't intend, I intend to, rest for the moment and let the public have their chance.
And that reservation of rights is with respect to direct and/or rebuttal testimony should you determine that you wish to present same.
That's correct.
Okay. And that is in accordance with the applicable procedure for quasi-judicial and judicial, for that matter, hearings. So I believe we're up to objectors at this point, and I believe there's at least one objector represented by counsel, and by one I mean I understand it to be an entity. I don't know, and I believe she wishes to present the case. Generally, Mr. Chairman, in those circumstances, the represented objector would put on their case before other members of the public who are not represented by that attorney have their public comment. It's incumbent upon me to ask, just to confirm, are there any other attorneys here representing any individuals or entities other than Ms. Dory, who is Dory, right?
Yes.
Who is representing the entity that she has stated as her client previously. Seeing none, it's a discretion of the chair, but it would be the usual approach to start with representing objector.
Please.
Thank you, Mr. Chair, Mr. Warner. So just as a matter of procedure, I had submitted a letter to the board after the last meeting. I understood from some of the discourse that the board wanted some kind of presentation or the materials submitted to them in advance of the hearing. So I did go ahead on February 24th and make a submission electronically to the board, which is the custom that I'd done before with submitting things. I did follow up, and I understand that my submission has not been distributed to the board. So I wanted to just procedurally address that because I have brought copies of my submission with me. I understand I have a cover letter that explains some of the positions for the board's benefit. You might have a position on that cover letter, but I do want to introduce the documents. And I also have a witness here, Mr. Eric Keller. I would like him to be able to testify this evening to the board.
Mr. Chairman, I'm sorry, if you're done.
Yes.
Mr. Chairman, while I certainly can opine on saying it would be prudent to involve Mr. Levine as well, particularly if he were to concur with both you and I, Ms. Dory, that might even be prudent and beneficial. So certainly, Mr. Levine, the objector entity has the right to present an objector's case and to call appropriate witnesses, correct?
Yes, that's correct.
Okay. And Mr. Keller, would he be appearing as an engineer, a traffic engineer, a planner, some or all of the above?
All of the above.
All of the above. Okay. Mr. Levine, you would concur that since you had an engineer, civil engineer, a traffic engineer, and a planner, that would be appropriate, and you have no objection to the objector having those three witnesses, albeit in one individual.
I don't.
Okay, thank you for confirming that on the record.
Mr. Chair, I have a quick question. So I'm a little confused. If a letter was supposed to be provided to the board in advance, why was it not provided to
I'm going to
said
get
board?
to that, Board Member Sacramento there. Thank you. Now that we've confirmed, sort of the low-hanging fruit first, now that we've confirmed those rights, which in my opinion are obvious, my understanding of the letter is it included at least some exhibits of which there was a previous determination by the board, at least preliminarily or at the time, that some of that evidence may be irrelevant to this particular application. Some of it, as I recall, relating to the settlement agreement, the deed restrictions and the like, some of which, or perhaps all of which were addressed to some degree already even this evening. What is appropriate, in my opinion, is for each exhibit to be sought to be presented along with the appropriate testimony and in the due process, quasi-judicial process. If Mr. Levine has no objection, I suspect the board has no objection. We'll hear it and see it and consider it. If he has an objection, there will be argument, presumably amongst the two, by the two of you. I'll advise the board, and they will decide whether they will admit the evidence or not. So prudence would dictate in due process and the like, which shouldn't be, which is important to consider. In my opinion, requires that we do it exhibit by exhibit with the appropriate witness.
Okay, and with that being said, I did mention at the beginning of the hearing that I have bought collated sets of my submission of February 24th for the board and also for Mr. Levine and the board's professionals. So I do have copies of those, and I understand you do want to go exhibit by exhibit, but could I pass around the compiled package, and if exhibits aren't admitted, then those can be removed?
I think it would be more appropriate to just make a proffer of what the substance matter is of each individual exhibit, and I think there can be a very fruitful and thorough, vetting on that basis. Yeah, I guess the only other thing, where I would say, I think that procedure makes a lot of sense. I think it's great. The only thing I would question a bit is I don't know to what extent it's fully accurate to say that the initial rulings that were made the first time that Ms. Story attempted to submit some of these materials was preliminary in any sense. I mean, she made a full argument in favor of why she thought they were relevant and should be submitted. There was a perfectly qualified board attorney here that evening, that advised the board. And
I hope there's one this evening too.
Well, as well as this evening, there was a formal decision made. And in fact, Ms. Story herself and all of her subsequent correspondence makes no bones about it, says, I want to reiterate the argument that I set forth on the record December 18th. So this was argued. I made my points. She made her points. It was discussed among the board members. A ruling was made. So I don't know in what sense that's preliminary.
I'll explain with the chair's permission. That determination was made at that time based on the evidence presented at that time. The process is one that evolves. Hopefully it progresses. It doesn't regress or digress, but it evolves certainly. So by preliminary, I mean that at any given point in time, based on the evidence, and there's been more evidence thus far, and there'll be more to come. I, as the board attorney, may make a you will address it, both, I suspect. I will advise the board. The board will make a determination as to whether particular evidence is or is not relevant and admissible for the board to consider. So something that may have been deemed not sufficiently relevant and therefore admissible a month or so ago, maybe today or next meeting. I'm not going to go beyond next meeting in my discussion right now. They might be relevant and admissible. So therefore, I'll advise and the board will determine at the time when each piece of evidence is submitted.
Mr. Warner, I just have a quick question for clarification. So it seems that the applicant is able to present and provide to the board in an unfiltered manner various exhibits. Who is the arbiter of what gets distributed to the board? It sounds like there's some sort of filtering going on here, and I just want to know who has that authority.
The board rendered a determination that I'm characterizing as preliminary for the reason I just explained. It's an ongoing determination. But based on that determination that was made at the time, what was sought to be submitted had evidence that was already determined by the board to be irrelevant and admissible. It may continue to be, or it may not continue to be. So that is why, in my opinion, it is prudent for that evidence to be submitted by the applicant with the applicant's witnesses. The applicant will certainly, I expect, argue it's relevant and admissible and tell us why. Mr. Levine may agree. He may disagree and tell us why he disagrees. And if the board will allow me, I'll weigh in on my opinion based on their arguments, and the board will be the ultimate arbiter.
So we'll have to vote on each piece.
Well, I guess it's TBD, I think is the acronym.
I'm just trying to understand
Yes,
the
yes.
process, because obviously this is a different phase of the proceedings, and it sounds like there's one set of standards that apply to.
No, the applicant has the burden of proof.
Okay.
And so they submit what they deem to be relevant and admissible. At the end of this, we'll determine whether it was enough or not, but so to speak. But the objector party sought to have the board consider items that, at least at the time and for now, were determined to be not relevant and admissible for some of the reasons we ended up talking about a little earlier this evening. So it's not a different standard or a different process. It's a different, very different circumstances that exist. But certainly the objector will be given an opportunity to seek to submit every bit of evidence that they wish to And if the board ultimately deems it's relevant and admissible, they'll accept it. It's also possible the board will determine that it can be introduced, and it may or may not ultimately be determined to be relevant and admissible, but that the board may determine that it can make that determination at the appropriate time, at the conclusion. This all remains to be TBD, remains to be determined in a prudent fashion. In my opinion, that prudent fashion abided by due process and the procedures for quasi judicial hearings would be as I stated.
Thank you for the clarification. Hopefully that benefits everyone, that clarification.
I hope they all do. We'll do our best.
I have a question too. Is it possible to see the exhibits, if there are copies of the exhibits, so we can follow along?
I think
Yes.
they get. My understanding is we're going to get them as they go. Exhibits come with testimony, like the applicant's exhibits. The engineers' reports, the plans, the architects, it's the traffic engineer, etc. So I assume we'll be getting them. Well, with Mr. Keller in his various capacities, expert capacities, we'll be getting that. I assume, but we want the objector to make their case as they wish, just as the applicant wished to make their case. And again, it's the applicant's burden. It's not the objector's burden to prove. It's the applicant's burden to establish their entitlement. We already addressed to some degree what that standard is. So with the chair's permission, please present your witnesses and your case.
Just before, so to clarify though, she said they're collated, so she'll give them every single piece of evidence to us.
Are you able to break them up, so to speak, or?
Well,
if
so
it's gonna
I
be-
mentioned it earlier, is I did bring collated sets. So, I would propose that we hand them out as collated sets, just to make it easier,
Can we
and
get a
then go
proffer then
document
per
by
Mr.
document.
Levine? Because that's the alternative way as to what's in there, so that it may end up being a situation where he.
Well, I can identify each of the documents,
Sure.
if maybe that would help, okay?
It would, yeah.
And then we'll go from there, all right? So the first document was my February 24th, 2025 letter. And the reason that I submitted this letter is because at the end of the hearing last week, I believe Mr. Warner and perhaps the chair is suggesting that the opposition or the objector could make a submission to the board and that it should be submitted 10 days in advance of the hearing. This February 24th cover letter contains, my arguments, but also the objections that my client has to the application. Much of this will be presented in the argument today, as well as Mr. Keller's testimony. So this is really a summary of the position of the objector. So that's the purpose of my February 24th, 25 letter.
Mr. Levine, do you have an objection or no objection?
No objection.
Okay, that would comport frankly with my advice, so.
Okay, and
One is coming.
So would we mark this now? Would you like to pick a number? Are we up to 3 or?
Well, I think we're,
we're
have we
starting?
marked objectors exhibits? My
There's at
apologies.
least an 01.
Is there- Let's make sure we,
Yes, this will be.
this will be O2. Okay, thank you. O2.
Okay. So my February 24th, 2025 letter will be marked as Objector's Exhibit 2, and I will provide a copy to all of you when I get through the rest of these. So also attached was my January 6th, 2025 letter, which I had submitted. I initially submitted a copy of the letter to you, Mr. Warner, as well as the board's secretary, Mr. Levine, and the other attorney that was there at the time. These are my objections regarding the documents that were admitted at the December 18th, 2024 hearing, which I will also be discussing again this evening. So that's my cover letter, which is dated January 6th, 2025.
And I'm sorry if I may have misheard you. Did you say there are objections to documents that were admitted, or your objections to documents that were not admitted at the time that you wish to have admitted?
Yes, objections, the latter.
The latter. That's what I thought you meant to say. Okay. With the chair's permission, all of this is with the chair's permission. Stop me if I don't have your permission.
That sounds good.
Please, Mr. Levine, please, do you, no objection, Mr. Levine?
We're talking about just admitting the January 6th letter?
Yes.
And
Yes.
which outlines for, no objection.
Okay, so this is January 6th letter. And there were two January 6th letters. One just attached the documents, but the one that I'm referring to now is the January 6th letter, which is about 3 pages. And it did not attach the documents, and it's with the objector's position, so I'll mark that as 03, okay? And then we have my January 6th letter, but that actually attaches the documents. And those documents that are attached to it, the first is the November 15th, 2019 settlement agreement between.
I'm sorry, one more time.
The November 15, 2019 settlement agreement.
Settlement agreement, okay.
Yes, between the township, the zoning board, and this applicant related to a zoning board application for the properties next door, 1 Jefferson and 7 Jefferson for a house of worship. So, excuse me, the settlement agreement, I'm mixing up the two documents. I apologize. The settlement agreement relates to that application as well as other litigation with the township and the continued use of 1 Jefferson for house of worship operations. So this was related to the testimony of the rabbi at the December 4th, 2024 hearing. The rabbi actually testified to this settlement agreement. And at the time of the subsequent hearing on December 18th, I had tried to introduce this document into the record to cross-examine the witness. At this time, I'm offering it to the board. I'm proffering it as an exhibit to be offered as part of the record of this application because it was directly testified to by the witness. I believe that the witness's characterization of the document is not complete. I think the board should have the benefit of the entire settlement agreement in deciding the application and considering the applicant's witness.
And if I may, the relevance to the this application for this development proposal on this site, 165 Old Short Hills Road, what is the proffer as to how that settlement agreement is relevant to issues that the applicant has the burden of demonstrating and you as objector are in essence defending that effort for this application?
This relates to the testimony of the applicant's witness, the rabbi, that the property next door was presently having operations for a house of worship and that those operations would be moved to the next door property and that the operations at 1 Jefferson would cease. So there were limitations on the use of the 1 Jefferson property. I think that the planning board should consider the settlement agreement that was directly testified to by the witness and have the benefit of reading the entire agreement and comparing it to the witness's testimony. And also it goes to the objector's position that the board should impose some reasonable conditions related to, to make sure that the applicant's representation that it will return 1 Jefferson to a residential property will be, a condition of approval of this application so that there are not 2 houses of worship next door to each other.
And is it your contention that the planning board has jurisdiction over that settlement agreement and or 1 Jefferson Avenue, that we can impose conditions on an approval with respect to Old Short Hills Road as to what can or cannot happen on 1 or 5-7 Jefferson?
Well, I'm offering the settlement agreement for the board to consider the settlement agreement because it was directly testified to by the applicant's witness, and I believe that the characterization of it was different from what the document is.
What's your
and that
proffer
the
as
board,
to how it was different and how it's relevant to this application?
well, the applicant has testified that there were operations for a house of worship at 1 Jefferson, and that there was a congregation that's been there for a long time, and that it's been operating at that property. It's been permitted with the agreement of the township, and there's actually a lot of restrictions on the use of that 1 Jefferson property.
And assuming all that to be true, how is that within the jurisdiction of this planning board for an application for development on 165 Old Short Hills Road? They can only decide whether or not the applicant meets their burden of proof to do what they're proposing to do and develop what they're proposing to develop on the lot that they're proposing to do it and develop it on. Whatever it may say in those documents, and assuming they say what you would say they would say, isn't that the subject matter that is outside the jurisdiction of this planning board for purposes of this hearing and this application for development, if there was a court involved or whatever, even if it related to this application, it would frankly, perhaps, I suspect, would be outside the jurisdiction of this board. But we're talking about a different, as I understand what you're saying, a different application for development that previously occurred, different uses on a different lot, none of which are before this board right now. And the reason I do this is very simple, and I hope everyone understands. Our board can't decide something that it doesn't have the jurisdiction to decide. And it's my job to help make sure that you decide what you have to decide, and you don't decide what the law precludes you from deciding. So that's why we're going through this effort.
Yes, so I'm not asking the board to decide something that it's not supposed to decide. So number one, the reason to admit the document is because it's directly testified to by the witness, and this board is a quasi-judicial body, just like a court of law. I can take recognition of an agreement that's been signed by the Township of Millburn, the zoning board, and the applicant related to the property next door, which was testified to by the applicant's witness.
And what was your proffer as to what he testified to that would make it relevant for this board to consider what is in that settlement agreement? And
The
what restrictions
characterization-
may relate to the Jefferson Avenue property?
The witness's characterization of what the settlement agreement allowed their congregation to continue to do at the property.
At Jefferson Avenue?
At 1 Jefferson, yes.
That isn't, again, I'm asking you, that's 1 Jefferson Avenue. This board only has jurisdiction, and if you can cite me some authority, but to the contrary, to this particular application for development on 165 Old Short Hills Road.
And the relevancy is that these properties are intertwined because the applicant has made a representation as part of this application that is going to return the property next door at 1 Jefferson to residential use if this application is approved. And that's
Well,
what,
if they do or don't do something.
Mr.
that
Warner, with all due respect,
Yeah.
I think you've made your position clear, and I think you made it clear that it's up to this body to decide whether we admit the evidence or not. So shouldn't we vote on that?
Certainly after, and I have no position, let me be very clear. I'm asking the questions to try to understand the jurisdiction. Ultimately, I'll advise the board. But I'm trying to, frankly, elicit from Ms. Dory her full argument as to why it's relevant to this board. Mr. Levine should have an opportunity as well to weigh in if he has a position.
right. And if
If you've exhausted
I just wanted to
your
add one more thing.
explanation.
Yeah, I
if
just
not,
want to
then
add one
please-
more thing, is
yeah,
that
please
the board
continue.
considered evidence of the rabbi's testimony, which related to this settlement agreement. And I think that the board should have the benefit of the settlement agreement itself in evaluating that evidence of the rabbi's testimony.
Okay.
That's really the
Okay.
crux of it.
And if that's your entire argument, and Mr. Levine, do you stipulate to that being admitted to the board, or do you object? And if you object, what is your objection basis?
I would just like to move, I think just on its face, it's plainly irrelevant and just kind of pollutes the record with more superfluous information that's only going to lead to more distractions and more time consumption. I think it's quite clear that a different property from 6 years in the past, so I understand it, settlement agreement arose out of an application before a different board seeking very, very different relief. I think it's quite clear that it's irrelevant, but I don't plan to belabor the point. I'll leave it to the board to decide. But I wouldn't stipulate to its relevance, but I'll leave it to the board.
Can I ask Ms. Dory a question? Mr. Chair?
Yes, please, Campbell.
Ms. Dory, is this all relevant because of the deed? Is this property part of the deed that is on 165?
This is not related to any type of deed restriction. These are really, the settlement agreement was related to a zoning board application and other litigation stemming from that was denied.
Thank you.
So I have a question. So just to be clear, and for the avoidance of all doubt, your claim is that the document you're trying to enter into evidence was testified to by the applicant. And at some point, you're going to make your case, and you feel that it is useful for the board to have that evidence as it relates to the testimony. Is that a correct understanding?
Yes, to have a full record, yes.
So it sounds like as a board, we have to make that determination as to whether we want to allow it. And Mr. Warner, it's my understanding that, as you said earlier, even if we choose to allow it now, that doesn't necessarily mean that we will consider it during our decision-making process.
And, but, excuse me, well, that's for the chair, but decorum. The board member Saccomondi, that is why I intentionally said what I said. It may not be relevant at all, but if the board is able to ultimately make that determination after hearing the arguments from both counsel, and I certainly trust the board to be able to make the appropriate determinations as to relevancy, if any, of a document, then the board can allow it to be introduced, and ultimately may or may not give it consideration, may give it a certain weight, may give it a lot of weight, a little none.
So it sounds like in that case, it would be prudent to omit it, and it will be determined later whether or not it's relevant or should be considered.
If that's the pleasure of the board, the applicant the objector, will be admitting that document.
Can I ask a question? Is it just because of completeness of the application and just the direct testimony, or does it also speak to the character of the applicant?
No, it's not going to the character of the applicant. It's going to the witness's testimony, which directly testified to it, as well as the fact that the board should have it for completeness of the record because it was directly testified to.
So, Mr. You reiterated several times it was directly testified to. Do you have a recollection as to the scope and the extensiveness of that testimony? Are we talking about 2 sentences, 2 minutes, 2 hours?
It was testified to by the applicant. I don't know the time frame, but it's your witness, and it was testified to by him at, I believe, at the
Is Mr.
first
Keller
hearing.
going to utilize this, or is this more for
No, this is
cross-examination?
really just for completeness, and I'd like to have it considered by the board. And like you said, the board can decide its relevance.
My understanding is that your prior explanation to the board, and they go all the way back to December 18th as to why you felt it was important, was specifically to challenge the credibility and to impugn the witness. It's not just a matter of completeness.
Well, at this point, I'm admitting it for the reasons I've stated
This time or the December 18th?
today. And I've explained to the board my reasons, and I'm asking the board to consider it.
I think we're at a
I'm not
point
trying to
where,
be argumentative.
I'm sorry, where the board has heard argument from both counsel, and it's up to the board to decide. It's not a vote per se, but it's a polling, if you will. If a majority of the board wishes to consider it or to have it introduced and to give it whatever weight, ultimately, if any, the board intends to give it based on whatever relevance it may or may not have, it's the pleasure of the board. I would simply suggest that you quickly poll the board.
I'll say, yeah.
Well, and we have 9 regular members, so.
Looks like it's gonna go.
Right, okay. So the board has made a determination it could be introduced, and the board, we trust the board to give it whatever weight it deserves ultimately.
Okay, I'm sorry. So you said it was submitted? Yes?
You got 04 in.
Okay, thank you. 04. Okay, thank you. Okay, and the next document is.
And I'm sorry, how many are there? I didn't think there were that many, but.
This is.
Oh, it doesn't, you don't have to.
Yeah, it's really the bulk of it. There's just a few more. The next one is the June 25th, 2012 zoning board resolution of denial. This is also for the properties next door, and it was another decision of a land use board of this township that denied an application for a house of worship for the 2 properties next door. I think that the planning board, as a quasi-judicial body, can take recognition of the board's resolution on these prior applications for a house of worship for the properties next door when it's considering this application. So that's the reason I'm at. It's also referenced in the settlement agreement.
Okay, and again, just one question, the relevancy of it to this particular application in your contention is?
Because another land use board of this township made a decision to deny an application for a house of worship for the lots next door, and had very thorough reasoning. It's a lengthy resolution concerning what the board considered in that application, and it's referenced in the settlement agreement.
Can I ask you a question? Did the zoning board back in 2012 consider it on conditional use or on variance?
It was a use variance application.
It was a use variance.
Yes.
Was it a conditional use, D3?
No, I don't believe so.
No.
D1 use?
I believe so, yes.
And again, it was just for clarification, confirmation. It was Jefferson Avenue, not this site. It was a different application by a different board with different standards for different relief, correct?
Yes.
Okay.
Sounds relevant to me.
Well, I'm just want to make it clear for the board and for the record. Ultimately, the board will decide, but in fairness, Mr. Levine, do you have no objection or do you have an objection? If so, what's the objection?
I object for obvious reasons. I mean, the burden was not the same on the applicant. The board was not applying the same standards. It was under an entirely different section of the ordinance, applying entirely different legal standards years ago to a different property. We don't even know to what extent the dimensions of the proposed structure were the same, different, what the setbacks were. It couldn't possibly be relevant.
And my advice to the board is that first, based on the proffer by Objector's counsel, it appears to me as if there is no relevancy of this document on this application, which is different, for this development, which is different, for this site, which is different, for the relief sought herein, which is different, materially different, and the standards of which are obviously materially different as well. That said, again, I trust the board ultimately, but if it is the board's ultimate determination to have it introduced and to see when this matter is concluded, if the board has that same opinion with respect to that document. But legally, the law governs.
Can I ask a question of the attorney, please? Oh, yeah. So you mentioned that this previous action that you now want to introduce was referenced in the settlement agreement that you're also going to introduce.
Yes.
Which seemed to be a little more ambiguous as to whether it was relevant than what you're currently talking about with this previous application. But is it necessary in order to understand the settlement agreement to have this second document introduced?
Yes, I think it's helpful for completeness for the board to have both of these documents, so that's why I'm introducing both of them. Or proffering them.
But this document you're attempting to introduce, this was not testified to by the applicant, brought up by the applicant.
Well, there is a pretty extensive explanation, I think, by the applicant in their application materials regarding the history of this property and litigation with the township, and that was testified to by the applicant's witness. So I think as a matter of completeness, the board should consider it.
So you're saying references to this were in the original application that was submitted to this planning board for this matter?
I believe that there was some summary of litigation by the applicant in their application materials. But it was also testified to by the applicant, by the applicant's witness, that there was litigation. So I'm providing the settlement agreement. It references litigation as well as the denial resolution, which is the source of litigation.
Satisfied with the answer?
It's an answer. I think the board has to decide whether it's
All right.
satisfactory.
I think it's important to understand that this is a different application, where there was a variance in that case, which is totally different to this situation. So I don't know how it's going to help us to make a decision. It's a different situation.
In fact, it might arguably confuse the situation.
Yeah, so
Agreed. I think that if it wasn't, the previous one, I think, had some
Yeah.
relevance, potentially, we don't know.
Yeah, we don't know.
But this one certainly seems like it's not relevant.
Correct.
I agree.
Okay, so this one is not.
Okay, so
Not-
2012 resolution is out, yes.
Yes.
Okay, so I'll have to pull that one out of the package. So the next document is the February 24th, 2025 report of Eric Keller of Bowman Consulting, and Mr. Keller is here this evening to testify to his report.
No objection.
So I-
05 is Mr. Keller's report.
Thank you. Um, The other documents, okay, the next one I have is a August 15th, 2016 appellate division decision. And this is related to the property, the subject property, 165 Old Church Hills Road, as well as the adjacent property, 1 Jefferson. This is also for completeness, and because it's referenced in the documents that were submitted by the application as part of their application, the 2014 judgment was submitted in the title documents. It was also part of my cross-examination of the rabbi. This 2016 decision of the appellate division concerns deed restrictions that were questioned. There was a lot of questions from the
I don't have
planning.
any, we don't have any.
I'm still
She doesn't have
speaking.
the problem.
Okay.
I think
It's already part of the application, it's already part of the record. We-
Okay, well, okay.
That was an interruption, but it might have been worthwhile.
Okay. So the appellate division, thank you, decision, thank you.
So that's
is-
06.
Is 06. Okay, and then the 2014 judgment is in there. It's already part of the application, but we can mark it if you'd like. Do you want to? It's just a,
Now for me to decide, do
This
you
is-
wish to introduce it as an exhibit?
yes.
Okay, then it's no objection?
No objection.
It's 07.
And the last document is a November 13th, 2019 order entered by the Chancery Division related to a motion to enforce litigants' rights. When the House of Worship operations continued at 1 Jefferson after the judgment was entered, the former owner of 165 Old Short Hills Road filed an application to enforce litigants' rights to enforce a deed restriction. So this is for completeness. It's part of what's referenced in the it's related to the 2016 appellate division decision that's also been submitted.
With the chair's permission, Mr. Levine?
I guess just, are you alleging that that was also part of the rabbi's direct testimony? And that's why it's relevant?
No, but this is a court order. I think the board can consider it. It's as a matter of completeness. It's also mentioned in my letter.
Yeah,
And
other
just
than
out
the
of curiosity, you, if I may, you mentioned it was related, or I believe you said, to the appellate division decision in 2016, but this did come 3 years later, correct?
Right,
Okay,
because
so if you could just clarify for me what you meant by related.
because even though in 2014, the Chancery Division entered an order, a judgment to prohibit the use of 1 Jefferson as a house of worship. In 2016, the appellate division upheld that decision. Subsequently, certification was denied by the Supreme Court of New Jersey. Despite that judgment, the operations continued at 1 Jefferson of a house of worship.
This is all by way of proffer for the board,
all
just
by
to
way of
remember, not
proffer.
evidence, please.
Those
What the
operations.
attorneys say is proffer.
The operations of a house of worship continued on that property, and so the former owner of 165 Old Short Hills Road filed a motion to enforce litigants' rights. So this is the order granting that motion to enforce litigants' rights, and I've referenced it in my letter. So this is, as a matter of completeness, I'm submitting it to the board.
What's the date on that?
Excuse me?
What was the date on that?
November 13th, 2019.
As part of your proffer, Ms. Story, are you claiming that other than the owner of 165 Old Short Hills Road, the subject of our application, are there any other beneficiaries of that that order and that judgment?
I'm not making any kind of legal opinion as to the beneficiaries of this order. I'm submitting the order because it's referenced in my letter. It's related to the court decision. And I'm offering it to the board as a matter of completeness. As a quasi-judicial body, the board can consider a court order related to the application.
Certainly if it's relevant, but ultimately it may be that the board determines to have it introduced and ultimately decide whether it is or it isn't. But Mr. Levine, do you object? Is the first question.
So I'll just simply say this is somewhat different than the other two documents in that well, my client tells me that this motion to enforce litigants' rights is also as a matter of public record as entitled. So if that's the case, I certainly don't have an objection. It's already part of our application. To the extent that it's not, I know that the other two documents were, and it was already, again, part of the record, part of our application. It's sounds like it's a motion with regard to the enforcement of private deed restrictions, which we had a fairly involved discussion about earlier, where it was ultimately decided that that is a separate parallel track. It's a matter of private contractual relations, not within the purview or the jurisdiction of this board. So assuming that to be true, and I certainly agree with that position, that would make this particular document irrelevant.
And is that an objection, and is that the basis for your objection?
Yes to both. An objection, and that's why.
Okay, and it's for the board to determine.
I'm confused. Is it already part of the application and the record, or is it not?
I honestly don't know. Sir, the rabbi seems to think that it is, so you know, he knows this property inside and out. I don't recall offhand. If it is, it's non-issue. It's already there.
So the applicant, so if it's already there, then
Good to go. We don't care.
We don't care.
The only people that benefit.
Wait, sir, you can't. Right? Your counsel can
Yeah,
at this stage.
happy to clear things up if I can.
Well, through your counsel, thank you. I'm sorry, back to the chair.
No, I think if it's already in there, then it's exhibit number 8.
Okay, Exhibit 08, thank you. That's the November 13th, 2019 order. And the last document I have is a map, and I believe this is also already part of the record because it's part of the title. This is the 1897 filed map of the Short Hills Park Association, which includes the subject property, and it's related to the deed restrictions that have been, the board has asked about. So it's for
It's
completeness.
definitely in the title, sir.
In
It's
the
part
record.
of the record.
So there's no objection?
Nope.
Okay. 09.
Yes, thank you. So that's it, as far as documents. So I do have hard copies. They are collated sets. So if I could, I'll just take a minute to hand those out to you.
There's certainly, Mr. Chairman, my advice is we take them because now 01 through 09 are introduced most without objection.
will these get posted to the planning board website?
And they're part of the record of these proceedings now, at least as far as their introduction. So in my opinion, they should be.
Ms. Dory, could I just ask you before you hand those out, there is one I think that needs to be removed.
I think you said you were
Yeah.
going to remove one.
I was going to remove one, and it might be difficult because I think, well, actually, maybe. Okay. So it was the June 25th, 2012 resolution, I believe. That was the one that was not admitted, right? Everything else stays. So I think this one's separate. Just give me a minute. Unfortunately, this is the heaviest one, so I did not read it.
Didn't know how it was going to turn out. And I'm sure there's a website.
Can you just tell me how many sets you need?
Eileen, do we need 12? We have 11.
Well, 31. For your.
If you can get to around 14, that'd be great. But please go to the board members first.
So here I have 9.
We can start handing them out if you'd like, to the board.
Here we go, 10. So how many did you want, 14?
I believe so.
I think you copied me on the electronic signature. I think I want to.
I'll get you the last
We're gonna get this. Eileen, you'll get one for the record. And I think they're in order 01 through 09, so we could all track them that way, correct?
We need one more copy down here.
I'll read off the exhibit numbers again. Okay, I have 4 more.
Yeah, or one first for the
We need some
Yeah,
from
no,
board,
no,
some
yeah.
board members.
Okay.
One down there.
Thank you.
Okay.
Mr. Ray, would some of them be stapled together possibly? Because I think we may have about, if everybody can check, at least we have, looks like we have 5 stapled. So maybe
Only
someone-
5 documents? Okay. All right, wow. All right, well, let me list off the documents that I have. And then, you tell me what you're missing. Okay, so you have my cover letter, February 24th, 2025. That's Exhibit 02. Everyone has that, right?
Okay, you gotta be quiet.
Yeah.
You gotta.
Please.
Okay, so Exhibit 02 is my February 24th, 2025 cover letter. Exhibit 03 is my January 6th cover letter. Is that in the package?
Yes.
Yes?
It's out of order.
It's out of order, I apologize. Okay,
There's 2 on January 6th, but the shorter ones you enclosed, please find.
okay, there's-
That's also
no,
one.
right, we don't really need that, but the January 6th one that I marked is 03 is the 3-page January 6th
We
letter.
got that one.
Okay. 04 is the resolution attaching the 2019 settlement agreement.
That's 04.
Yes,
That's
05.
Resolution 19-257.
I'm sorry that you were asking for the, yes.
Okay, thank you. That's 04. Got it.
Okay, 05 is Mr. Keller's report from Bowman Engineering.
That's 05, February 24, correct?
Yes.
Okay, got that one.
06 is the appellate division decision. No, you
That's
haven't
not
got one.
here.
Okay, I'll have to look and see if I can get copies. Sorry? Oh.
No, I have that one.
Okay, well, I'll find the copies of 06 for you. 07 was the 2014 judgment? No? Okay, and 08 is the 2019 judgment, and 09, okay, it looks like you're missing copies of the last 4, which I will look in there and see if I have, but I am going to be starting with Mr. Keller. So I would like to start with his testimony, and you have his report. So-
We're gonna hold that because we have 5 minutes or 4 minutes.
Oh, okay, I
So
apologize.
we're gonna have to carry that till next week.
Okay.
Mr. Chairman, may I make a suggestion? Since we have some additional documents that have been allowed to be introduced, that you need to get to everybody, if it's, might be effective for you to send them to Ms. Davitt, who will distribute them to the board members to make sure they all, including the ones you gave out tonight, maybe you can get her one full digital set, can make it to the website as soon as possible, so that members of the public, everybody can have them, board members can have them, everyone can look at them in advance of the next hearing. I want to make sure that happens so that we can move swiftly come next hearing so that you can proceed with your objector's case.
Okay, I appreciate that. Thank you. I will be in touch with Ms. Davitt to make sure she has all the documents. Okay, thank you.
Can I have a motion to adjourn?
Wait, I'm sorry, we do have to announce. We're going to proceed with the objector's case on March 19th. Is that correct, Eileen?
March 19th.
And we have nothing in the pipeline right now. We're scheduled for that night, other than this.
And I believe perhaps the capital, the whole township hall, the renovations on board by the VA, that we might have something coming to the planning board in that regard.
Okay, so it's TBD, but,
Yeah.
okay.
But no application.
No applications, okay. And Mr. Levine?
Yes.
I'd be remiss if I didn't ask for an extension of time to act beyond the 20th in light of the fact that it might be fair to assume we'll need more than just one more hearing.
Excuse me. That may be so, but consistent with our practice in this case, my preference and my directive for my applicant is just through the next upcoming hearing the following day, the 20th.
Understood. All right, so with the chair's permission, this matter is being carried without further notice to March 19. Getting the dates correct tonight? Here at 7:30 PM. And we will be in this building, correct, Eileen? Okay, thank you, Mr. Chair.
All right, motion to adjourn. Second, all in favor?
Eileen?